this matter because my lord was a counsel here, my lord.
Okay.
27 and 28. Any
Let's
other
try
bench?
to list those matters again. List those matters before any other bench without me. When I was reading, I was, the facts were trommels that
Yes.
disposal of
That's
waste.
right, my lord. And when I was looking into the brief, my lord's name came in.
Okay,
So I
okay.
recognized.
But it was not there here in the.
Yeah, it's a second round litigation.
You have some urgency?
Yes, yes.
Because there is an interim order. I cannot.
Yes.
We'll have it tomorrow.
Tomorrow.
As prayed for by the learned counsel for the parties, registry to list this matter again on Kali date to Didia before the appropriate bench.
Deeply obliged. It's a contempt case, man. It is not listed many days.
Bench 4.
Contempt.
Bench 4.
Bench 3.
Bench 3. Bench 3, no. You'll have to go before the senior bench.
Bench 1 better, bench.
Senior judge. There is a senior bench. Yes, Mr. Kus.
Yes. Milord.
Yes, Mr. Rekha.
Yes, Milord. Item number 9, Milord. Here, Milord, in this matter, in Excel 6 incomplete order we have inadvertently left, Milord. So we need to file additional affidavit to brought on record. So 2 weeks time may be given, Milord. We have taken consent for the Excel department.
On the prayer of Mr. P.K. Deka, learned counsel for the petitioner, registry to list this matter again after 2 weeks on a date to be fixed.
Much obliged.
What is there left now in this matter?
Well, in Excel 6, page number 29. It is
your criminal case.
That's 2 page only. Yes.
Quashed. Complaint case withdrawn.
Withdrawal. Last page we have not.
No, fine. Withdrawn.
Yes.
Nothing is left. In this case, he has to take a call now whether the license suspension is to be restored or not. If not, why?
Then Lordship.
No. Finished. Adjourned.
After 2 weeks, Milord.
After 2 weeks. 3
Obliged,
weeks.
Milord.
May I pray for the listing of a petition for motion, my lord?
Bench 4.
Bench 4, the bench. Day after tomorrow, my lord. Deeply obliged.
That one motion matter pertaining to bench 4 lawsuit.
All bench 4 mentioned matters, give it to her.
May I please, your lordship, I beg to mention item number 18, your lordship. With the consent of other side, your lordship. I beg to mention for urgent this matter for there, your lordship.
You are for?
Petitioner, your lordship.
Sorry, rejected. You do it with your left hand first. And then you go and do it with your right hand. Now you can lift the materials. What is left here in this case? I think it's a case for imposition of cost. We'll see when the matter is reached. Be here when the matter is called. Yes, Mr. Islam.
My lord, I beg to mention item number 49. And in this case, my lord, I have filed an interlocutory application for substitution, my lord. That interlocutory application has not come up, my lord.
Substitution of?
Substitution of the representative of the society, my lord. The earlier secretary who was resigned from the
Mr. R. Islam,
maybe taken out Friday.
Council for the petitioner submits that he has filed an interlocutory application for substitution of the representatives of the petitioner society. So he prays that the present petition be taken up along with this said interlocutory application. Prayer accepted. Registry to list this matter again next week along with this said interlocutory.
Friday, my lord?
On Friday. Friday would be Monday. On so and so date.
It is your lordship. Lordship, with the concern on the other side, I beg to mention item number 25 of today's daily list. Lordship, regarding this matter, there was some query which was asked by the Honorable Court. That query we have sought for instructions and that is still pending.
What is the big thing you got to give? How have you extended the defect liability period after the defect liability period was?
Yes, Lordship.
5 years?
Lordship.
That formula of extension came in 2025.
Lordship.
This was a contract much prior thereto.
Lordship.
Get your instructions. We'll not keep this matter pending.
Lordship.
We'll see when the matter is.
Lordship. Much
Lordship.
Yes, ma'am.
Lordship, I'd like to mention item number 30 and 31 for adjournment, Lordship.
Right?
Lordship, my senior has some difficulty. He has undergone
A
surgery.
prayer is made on behalf of Mr. K.K. Mount, learned senior counsel for an adjournment in the matter on account of person inconvenience. Also,
I'm respondent.
Ms. M.D. Bora, learned standing counsel, transport department does not object to the said prayer. Accordingly, registry to list those matters again after 2 weeks on a date to be fixed.
Lordship, interim may be extended.
Interim order passed earlier. Yeah, we did. Yeah. So to list this matter again,
Lordship, there is an interim order. It has been extended.
interim order, if any, to continue till the next date of listing. Registry to list this matter again on documentary, on 15/6/2026.
15/6. No, Lordship, after that.
Huh?
He's undergone surgery. Actually, he's
Sir
undergone
has undergone surgery. Okay, when? Give me a date.
in third week of June.
That is 15th of June. You want it little bit,
after vacation,
Not after vacation, before vacation, any date.
you want it before vacation?
Yes,
Let it be.
Okay, on 22nd.
much obliged.
Sir has recovered now or?
He has to undergo surgery in another eye. That's why.
Okay.
Yes. Much-
I have instruction to not to face the matter.
You are for the petitioner.
Yes, ma'am.
Any interim order?
Yes, ma'am. There was an interim order not to finalize the tender process. Ma'am.
Mr. Andeka, learned counsel for the petitioner. On instruction submit that he be on instruction submit that the petitioner desires not to press the matter further, any further. Accordingly, he prays that he be permitted to withdraw the same. Prayer is not objected to by the learned counsel for the respondents. Accordingly, the petition stands dismissed on withdrawal. Interim orders passed earlier stand vacated.
Reply obliged.
Yes, where is Ms. Deka?
Your Lordship, kindly pass over the matter for the time being.
She is here. She has the instruction.
She's on her way.
After some time.
Well, page number 14 is the relevant part of the court order. Page number 14, paragraph number 10.
Nobody has appeared.
My lord, today is the first day, my lord. Notice should go to the contempt, respondent contempt.
It is which department?
My lord, government, my lord. Yeah, press.
Leha. The present, I heard Mr.
Please shake, my lord.
Learned Counsel, T. Sheikh, SK, huh? TSK, Learned Counsel for the petitioner. The present writ petition has been instituted alleging violation of the directions passed by this court-wide order dated 18/9/2025 in WPC number 735/2025. So, the petitioner earlier had also instituted contempt case bracketed C number 661/2025 on the same grounds, and the said contempt case was closed wide on order dated 19/1/2026 on this court being apprised that the orders directions passed by this court in WPC number 735/2025 was complied with by the respondents while issuance of an order dated 15/12/2025. It is alleged that the respondents, while issuing the order dated 15/12/2025, have not complied with the directions passed by this court while the order dated 18/9/2025 in WPC number 735/2022, and accordingly, a violation of the said directions have occasion. Issue notice returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents by way of speed post steps within 2 working days from now.
This application has been filed for non-compliance.
Mr. R. Islam, learned counsel for the petitioner. issue notice returnable 4 weeks. File alleging violation of the directions passed by this court by judgment and order dated 3/11/2025 in WPC number 6855/2024. 2024. Issue notice. Respondents. No, respondents, huh? Steps 2 days.
But
As for the lordship is directed to this instruction.
Lordship, yes, Lordship, the date of upload date, Lordship, respondent 5 Jivon Gogoi on 23/03/2026. 23/03/2026. R5
23/0.
And
he has given
yes, he has given month of February. And respondent 6, Gautam Gogoi, uploaded his bid on 23/03/2026. He submitted the period for February, Lordship. This is the record, Lordship.
Then the rule 15 will come into play, my lord. The rule 15(2) will come into play. You should have.
I'm sorry, will not.
No.
This is a material condition. This is a mandatory condition. Now, the cutoff limit for filing of GST is a GSTRP 3B is, you're a monthly filer.
Yes, monthly filer.
So it is 20th of the next month. There are sometimes extensions given,
There's sometimes.
but 20th. Now, you have failed to file that within that time. They require the updated. Let us forget the extended one. Why the February month was not given?
It is not.
And it is not there even on the records of this case.
GST, my lord.
GST clearance challan of February is not here.
No, GST is in February is not there. January is there.
January will not be.
Because
It will be
the
February.
moment your January is not.
We are dismissing your petition.
February is not there, my lord. You should have, according to rule 15(2), you should say that you give the latest one.
No, need not be, because that is one of the mandatory conditions. I'm sure, I'm convinced that they have followed the.
The thing is that you should have applied the rule 15. That
Why? When others have, they have applied this uniformly across all. And the others who are qualified, they could give. Why couldn't you give? Why should you be given a favor?
because there are some few dates are there. Another 6, it is filed on. Bid was around 24/3. Another 7 days is there of that particular month, my lord.
Fine, 20th is the cutoff. You should have been prompt. You should have done it. You did not do it, and you have not even disclosed in your writ petition on which day GSTR 3B was filed by you for the month of February.
Later on, it doesn't file, my lord. I have not disclosed that particular date when it. I have filed.
Sorry.
Because 15(2), one of the rule will come into. They should have asked that you
15(2) will not come here.
GST is not up to date. You please.
This is not a historical document.
My lord,
Mr.
Lord, you kindly see that GST.
Mister, this is not a historical document.
My lord,
This is the mandatory condition in the tender.
Certificate, my lord. Tax challan certificate. It's a statutory thing, my lord. Tax challan certificate, it is saying. It includes the GST. Tax challan certificate PAN number, etc. So tax challan certificate is the
with
GST.
up-to-date challan.
Yes.
So that up-to-date challan not being there and
Not
they
being-
having uniformly applied, I don't think so.
That
This is the
opportunity,
case.
that opportunity should have been there, my lord. You have not did the up-to-date challan. You give the.
Why
up-to-date
should they give you when you had all the opportunity in your life to upload that?
No, later on.
This is not a date which is prior to 20th. This is a date after 20th.
No, after 28, my lord. The last date I have already.
If you want, I can issue a notice. That's all. We are not concerned. We'll reject your
Lordship
interest.
will issue notice.
Or we'll dispose of the petition. What choice is
Lordship
yours?
will issue notice, my lord. Let them file
But
affidavit.
Mr. S. Bora, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate, appearing for so and so. Issue notice returnable 4 weeks. Mr. Goswami accepts notice on behalf of respondent number 1,
1 to 4.
2, 3, and 4. No formal notice, huh? Petitioner to take steps for service of notice upon respondent number 5 and 6 by way of a registered post with AD. A registered post, speed post. Steps within 2 working days. The petitioner in the present petition has raised a grievance with regard to the declaration made by the tender. What is it called? Tender evaluation committee. The bid evaluation committee declaring the bid. Declaration made by the bid evaluation committee of the bid submitted by the petitioner to be non-responsive, being in violation of the provisions of clause 2A bracketed D bracketed 2 of the tender conditions. The petitioner, in pursuance to e-tender dated 25/2/2026, issued amongst others, inviting bids for construction of poultry house at District Poultry Farm, Demo in Sipsagar district, had submitted his bid on the last day of submission of bid as prescribed in the said tender, that is 24/3/2026. The bid of the petitioner on being processed by the technical bid of the petitioner on being processed by the bid evaluation committee in its meeting held on 11/5/2026, the bid evaluation committee proceeded to declare the bid of the petitioner to be non-responsive, being in non-conformity with the provisions of clause 2(a) bracketed D bracketed Roman 2 of the tender conditions. Subfact. The provisions of clause 2(a) bracketed D bracketed 2 of section 4 of the NIT mandates that the bidder must upload his GST registration certificate with up-to-date challan. The petitioner, while having uploaded his GST registration certificate, had uploaded the GSTR -3B challan for the month of January, although the bid was so uploaded by the petitioner on 24/3/2026. This court finds that the tender the bid evaluation committee on the same ground had rejected, had declared the bid of one another bidder to be also non-responsive. Amongst the 8 bidders who had submitted their bids for the work in question, it is the respondent number 5 and 6 whose bids were found to be responsive. This court on the last date had required the government, the Mr. Goswami, learned additional senior government advocate, to place on record the bids submitted by the respondent number 5 and 6. The bids complete. The bids submitted by, copies of the bid submitted by the respondent number 5 and 6 have been placed on record. This court, on a perusal of the said bids, find that both the respondent number 5 and 6 had also uploaded their bids on 23/3/2026 and had uploaded the GSTRB and uploaded the GST challan for the month of February. Accordingly, the respondent number 5 and 6 are found to have complied with the requirement in the provisions of clause 2A bracketed D bracketed 2 for uploading the latest updated challan. So the said requirement being a mandatory requirement, being a requirement for evaluation of the bid of submitted by the bidders, and the technical bid evaluation committee having found to have applied the set criteria uniformly amongst all the bidders, this court is of the considered view that the decision of the bid evaluation committee arrived at in its meeting held on 11/5/2026, holding the bid submitted by the petitioner to be non-responsive would not mandate to be kept in abeyance. Accordingly, the prayer of the petitioner for interim direction in the matter is rejected. However, it is provided that the award of contract in the matter would remain subject to the outcome of the
Lordship,
just add a few lines here and there.
Lordship, I am appearing here as a standing counsel.
Additional senior nominee, standing counsel,
Animal
animal
husbandry and
husbandry
veterinary.
and problem. All of nonsense.
Okay. Yeah, your
Yes,
Lordship. Matter pertains to non-payment of contractor bill. Page 14 is the liability statement, Lordship. It's an admitted amount and part payment already done.
But Miss K.K. Chaudhary, learned counsel for the petitioner. Also heard Mr.
S. Kotsu, your lordship.
S.
S. Kotsu.
Kotsu, learned counsel. You are appearing for?
Respondent 327, your lordship.
Appearing on
Water
behalf of
resource.
Mr.
On behalf of RM Das.
Mr. R.M. Das, learned standing counsel, Water Resources Department. Also heard Miss so-and-so. Who is appearing for respondent number 1 and 2? CGC?
A Gayan. A Gayan.
Miss A. Gayan, upar likhi bile. CGC Aru Tabishat is standing counsel. The petitioner in the present writ petition has prayed for a direction upon the respondent authorities to release her admitted contractual dues of rupees 62,802. A contractual dues are admitted now, a contractual dues of rupees so and so. The petitioner projects that the said dues submits that the petitioner having executed the work involved to the satisfaction of the departmental authorities and no objection being raised with regard to the same, the amount due to the petitioner must be deemed to be admitted. Mr. Swenso, learned counsel, learned counsel appearing for the Water Resources Department submits that he be permitted to complete his instructions and also issue notice returnable 4 weeks. Ms. A. Gayan accepts notice on, Ms. Gayan is here in court today. Your name? Huh? P. Rabha, learned counsel appearing on behalf of Ms. A. Gayan, learned CGC, accepts notice on behalf of respondent number 1 and 2, while Mr. So-and-so accepts notice on behalf of respondent number 3 to 7. No formal notice, as all the respondents are represented, no formal notice. However, requisite copy, extra copies, So, registry to list this matter immediately after 4 weeks.
Lordship,
Let them
date
file-
may be, date may be given.
13/7/2026.
Obliged.
Maybe. The matter regarding my lord, remission of the settlement amendment. On last Friday, my lord, the similar order has been passed by the honorable court. My lord.
That is page 32.
No, my lord, it was earlier order. It is my lord, last Friday, my lord. Facts are same, my lord, only change in paragraph 2, my lord. In paragraph 2, in the place of evening, it is morning, my lord. And the amount would be, my lord, 1,94,789.
Evening, it will be morning.
Morning.
And
1,94,789.
the date is 1/8/2025 to.
Yes, sir. All are same, my lord.
Similar. As doctor. Itu ba my bien? 2769.
Obliged.
Disposed of.
Here,
Yes, who is the standing counsel?
Myself.
What is this going on?
We have nothing to do with it,
You have nothing to do.
because
Sit down. Who is the water
it's not,
resources?
because they have ad posts.
So you admit that they are doing work which is disturbing the fishery.
Yes, Lordship, one thing we are saying that they have no right to ask for emissions. That part we are saying, because it is, they have agreed to that part. Page number 35.
35.
Clause 23.
We are only seeking some more time to, my lord, for payment.
They have no right to seek remission on any ground. It is in Bharnik.
Yes, what is the work you are doing there?
I have to take actions, ma'am.
You are on the bank, or you have gone right into the river
Yes,
for flood mitigating works.
Well, I have to get instruction.
Mr. Kolta,
Yes, my lord.
you got this tender a bit settled with you sometime in June.
This is July, my lord.
The agreement is of
11th of June.
11th of June. So while you entered into the agreement, you had gone to the place. You had satisfied yourself
Yes.
that this is the kima given to me. Now, these actions that you are saying
Yes.
is there from January.
No, 20 to 1/2026, my lord. This year.
Your settlement is 25.
25.
Okay. And this money, how can you deny?
No, my lord, I am not denying the money, my lord. I am seeking some time to only for
How
payment.
much time you want?
My lord, there's 6 months, my lord.
No, that is
Because
the-
my lord, it's a, my lord, 31 lakhs.
31 lakhs. It's up to your
No, Lord,
quotation.
The-
It is not something that they have quoted out of the blue. It is what you quoted.
my lord, the fingerlings what?
Where is the
we have-
material to show that the fingerlings have been disturbed? It has been, all thing have gone.
Washed out, my lord.
Nothing is there.
No, no, I have stated. In my report.
It's a bill.
It's a bill.
It's a flowing one or it's a block.
My lord, they have made a way to the river, my lord, Puthimari river now.
Hmm.
So that in the, my lord, the rainy season, water will enter into the bill, and when water of the river falls, the down, my lord, then water will flow to the.
So these works are complete.
Yes, my lord. No, my lord, going on.
Going on.
Going on.
Where is that loss that all the fingerlings that you put in there? Where is the material? We can't determine that.
No, my lord, I am not seeking any compensation by this writ petition, my lord. I am only seeking some time to pay the revenue, my lord. Because at this stage, my lord, it is very difficult for us to, my lord,
Then you
because
give
we
up.
are not able
Then
to
you
work,
give
my
up.
lord.
Somebody will, otherwise will run it. Government revenue will be saved.
So we have already, my lord, deposited
That is
21
gone.
lakhs of yes.
No,
And
no, this is the
35
current due.
35 lakhs we have deposited bank guarantee. So 55 lakhs already, my lord, in their.
Bank guarantee is not the KISS money.
Yes, yes, I admit.
This is KISS money.
This money, 21 lakhs, has already been deposited.
That is for the last year.
Yes, yes.
Now this is 31 is for this year.
Yes.
Then?
So we are paying, my lord, but I am not denying that.
3 months will not, we
I am
can't
not
give you
seeking any
6 months.
remission.
We
I
can't
am.
give you 6 months. Sorry.
I am not seeking any. Let me work, my lord. Let the work order be stayed, my lord. Let us work, my lord. We will pay, my lord.
Why? Why? That is public interest. Why should we?
Then, my
Why
lord,
should we? Show me.
it is
from
the, my lord,
Mr.
insubordination
Kolita-
between the
Mr.
departments,
Kolita-
my lord.
Mr. Kolita just making vague statements that some work is going on. That is why my bond is affected.
My lord,
How can we understand? Nothing is here.
no, my lord, kindly see, my lord, kindly see Annexure 14, my lord.
14.
Yes. Annexure 14, my lord. Page 56 and page 55. The managing director wrote a letter to the deputy commissioner.
This is just forwarding your representation.
Yes, my lord.
So that, how can I draw
My lord, work order
satisfaction
after
that
receipt of
because
work
of this
order.
work, your scope of work or the extent of the work you were actually allotted has reduced.
My lord, my submission is that, my
The
lord.
bill is still there.
My lord, my submission is that, my lord. One department settled the fishery with me, my lord, without discussing, without, my lord, any notice to me, my lord. How can they, my lord, work
That
here?
they have done it in public interest for mitigation.
Public interest,
That
my
is a
lord,
different thing altogether.
they ought to have cancelled my lord, the settlement order.
You don't pay, they'll cancel.
No, my
You
lord,
cancel.
let
You
them
cancel.
return the amount, my lord.
Why?
Let them
You
let
don't
them
pay
return
any
the amount
further.
to interest, my lord.
Rest they will recover from you. But Mr. N.K. Kolita, Learned Counsel for the petitioner. Also heard Mr. P. Sharma, Learned Standing Counsel,
AFDC,
Fisheries Department.
AFDC, Lord.
Upward Likibi. Why have you made the Brahmaputra board?
Well, flood mitigation is Amrit Sarovar are going under that department.
A. Gayan, Learned CGC. P. Sharma, Learned Standing Counsel, Fishery Department. And anybody more? And Ms. P. Chakraborty, Learned Standing Counsel, Water Resources Department. And Mr. G. Bokulia, Government Advocate. Issue notice, returnable 4 weeks. Ms. Rabha accepts notice on behalf of respondent number 1 and 2. Ms. P. Sharma accepts notice on behalf of respondent number 3, 4, 5, 6, 7, 8, 9. Mr. Bokulia accepts notice on behalf of respondent number 10. No formal notice, huh? Petitioner to take steps for service of notice upon respondent number 11. Also, considering the nature of the grievance raised in the present petition, the respondents are directed to complete their respective instructions by the next date of listing and apprise this court of their stand in the matter. The maintainability of the present petition is kept open.
my lord, till then, my lord, this notification, my lord, or an work order. my
I'm
lord.
sorry. We are not satisfied. Will not.
Then, my lord, where will go, my lord? Then,
You go wherever you want to be. You take a bill.
yes. And it is, my lord, duly settled, my lord.
Now,
We are valid
Mr.
settlement, my lord.
Kolita, show me that you cannot fish there. Anything. Nothing is there.
My lord, then let the matter be fixed after 1 week, my lord. Let them take instruction.
No, you satisfy me. If you want, I'll give you 1 week time. File an additional affidavit. Bring something to show us that the settlement and the fishing that way you were doing in 2025, now you cannot do. It's not there.
My lord, I have stated in affidavit, my lord. I have stated
Nothing. Those are your statements.
work order, my lord. Work order itself, it is mentioned that the bill includes, my lord. Work order.
I'm giving you. If you want, you file an additional affidavit, I'll give you time. 1 week time. No problem. You want to file an additional affidavit to bring on better particulars on it. Then we will see.
Okay, my lord.
On the prayer of Mr. N.K. Kolita, learned counsel for the petitioner, registered to list this matter again on
Next Monday.
10/6/2026. Mr. Kolita is granted liberty to bring on record, to file an additional affidavit, bringing on record better particulars with support of the claim made by him in the prison. Just
Alright.
give me some handle. We'll see.
Item 13, I am appearing for the petitioner, my lord. The petitioner is since assailing the arbitrary and illegal blacklisting order dated 20th of May, 2026, issued by the respond number 3. Now, respond number 3 is the state level nodal agency, my lord, that is Assam State Rural Livelihoods Mission, which was for implementation of the DDU GKY Yojana. So this
Any
was for
notice
the
issued
train.
to you prior to issuance of this 25/2026? Any notice
My
given
lord,
to you?
My lord, what is interesting is at page number 82. My lord, we'll see page 82 for a minute. I have now since invoked the arbitration clause that is forming a part of the memorandum.
That's a different
This-
thing. That's for your cancellation of your contract, not against blacklisting.
Not against blacklisting is the
Cancellation of your
response.
contract.
Correct. I'm so obliged.
Any notice given to you? No.
Not at all. Not at all, my lord. That is what I'm aggrieved of. If my lord sees the blacklisting order forming a part of Annexure 1 at page 29. So I'm concerned
Yes,
with
Mr.
page number.
Doctor. How is this permissible?
My lord, the recovery notices has been served, my lord.
Show me that notice informing him that you will be blacklisted was served on. Enough. The notice that you is referred to there, show cause notice,
My lord.
that you will find in page 65. That is with regard to termination. And termination per se, it cannot be also your blacklisting.
My lord. My lord, one short accommodation, I will take instruction on
We
that.
will stay this till that
My
time.
lord,
No,
3 days,
sorry,
my lord. 3
this
days.
cannot be permitted.
3 days only, my lord.
This cannot be permitted.
Maybe
I'll give you
tomorrow.
a week's time. In the meantime, we are staying.
Day after tomorrow, my lord. Only 2 days.
Today I'll stay it. Then you go, you come
My lord,
tomorrow also. I'll stay.
till day after tomorrow, my lord.
Because this is palpably illegal.
Till day after tomorrow, my lord.
Okay. But Mr. Your name?
And thus.
N.
And
Das,
thus.
N. Das, learned counsel for the petitioner. Also heard Mr. S. Doctor, learned standing counsel, Panchayat and Rural Development Department.
2, 3 and 5.
Mr. Doctor submits that he be granted time till Wednesday or Friday?
Friday.
Friday.
My lord, I'm so sorry, my lord. Friday, I'm out of the country. Can it be 3rd of June, if it is possible? Day after tomorrow. In Delhi, my lord, we are having a summer vacation. I'll be going out for some time.
You're going on?
I'm going on 4th, my lord.
4th.
On 4th of June, and I'm back on 18th of June. I'm so sorry, my lord. I'm seeking your lordship's accommodation.
How can I stop somebody from going
Third
to
June.
foreign country?
3rd June.
3/6/2026.
My lord, day after.
3/6/2026.
3, 6, yes.
To complete his instructions in the matter. Pray accepted. Registry to list this matter again on 3/6/2026 till the next returnable date. The order dated 25/2026 blacklisting the petitioner firm would remain in abeyance.
Lordship may observe that after the instruction.
Oh, that I have not even issued a notice here.
Well, obvious.
I'm
On
so
Wednesday.
obliged.
Well,
It is the petitioner company, my lord, not a firm. Petitioner company. It's a company.
Company, sorry.
Company. I'm so obliged.
Oh. Where is that? Are the earlier order? Heard Mr. S. Bhattakur, learned counsel for the petitioner, also heard Mr. M. Sharma, learned standing counsel. Indian Oil Corporation. no? Indian Oil Corporation. Your name, ma'am? Yes? Also, Pothomoto Likibi, R. Dev, appearing on behalf of S.S. Roy, CGC, and then M. Sharma, so and so. Huh? Issue notice. When have we fixed that case?
my lord,
Issue notice, returnable.
4 weeks still.
4 weeks, ma'am.
Returnable 4 weeks. Miss Roy accepts notice on behalf of respondent number 1. Miss Deb accepts notice on behalf of respondent number 1, while Mr. M. Sharma, learned standing counsel, IOC, no? Accepts notice on behalf of respondent number 2, 3,
4, 5, and 6.
5, and 6. No formal notice. Also, the learned counsel for the parties have submitted that the present writ petition, that the learned counsel for the petitioner has prayed for interim direction. The learned counsel for the parties have submitted that the interim direction as passed by this court in WPC number
2746. And
2746
2746.
Lots.
would also stand attracted to the present writ petition. Also, in view of the above submission, this court directs that registry to list this matter again after 4 weeks along with WPC number 2746/2026. Next case.
Next one. Deeply obliged.
Hope the facts and all, I've not applied my mind in this two cases. Everything is same.
Right.
The dates, LOA dates are slightly.
I've not even brought it.
No, my
I've
lord.
not even
The
brought it.
facts are.
Facts are same.
Implement of new incumbent, my lord. Implement of new incumbent, my lord.
Huh?
Implement of new
Oh.
incumbent.
After morning time, you are saying so softly, how will I hear?
My lord.
Don't shout, but
Earlier respondent number 1 is not in notice, my lord.
heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr.
NR Sharma, lordship.
N. Sharma.
NR Sharma.
N.R. Sharma, learned counsel appearing for the
BTC.
opposite party number
1.1.
for the opposite party. Also, you will accept notice on behalf of this newly implemented one, or notice has to go?
Lordship,
Notice has to go.
on behalf of Mr.
The
Moses,
petitioner.
lordship.
The applicant, by way of instituting the present writ petition, has prayed for impleading the present incumbent in the post of Principal Secretary, Bodoland Territorial Council as a party respondent in the connected contempt petition being contempt petition case number, contempt bracketed C number, COPC, number 158/2025. This court, on a perusal of the statement of the contentions raised by the applicant in the interlocutory application, as well as upon hearing the learned counsel for the parties, is of the considered view that the person sought to be impleaded as a respondent in the connected petition is the present is a necessary and proper party therein, and it is the and it is he who would now be required to comply with the directions passed by this court wide order dated 21/8/24 in WPC number 6125/2023. So, in view of the above, the petitioner is permitted to implead A to A, page 2, as a respondent number 3 in the connected contempt petition being COPC number, case number so and so 158/2025. With the above observations and direction, the present interlocutory application disposed of contempt applicable. In view of the order passed today in 1729/2026, ISC, impleading A to A, semicolon, as a respondent number 3 in the present contempt in the present petition, petitioner to file a amended cost title within 2 working days from today. On filing of such amended cost title, the petitioner to take steps for service of notice upon the newly impleaded respondent number 3 by way of speed post. Registry to list this matter again after 4 weeks on a date to be fixed. Right. To dispose quickly.
All right.
Sorry, Your Lordship, I could not attend in time.
What happened?
Lordship, I have received instruction. The court has requested me to take instruction, Your Lordship. It is stated that due to exhaustion of budget provision during financial year 2025-26, the demand for fund in connection with contempt case number so and so pertaining to the Abdul Ghaffur received under reference could not be processed, Your Lordship. So, Lordship, we have made for a fresh demand, Your Lordship, and we are going to pay in this current financial year, Lordship.
Current financial year will finish April 2027.
No, Lordship,
We'll
kindly,
wait till April 2027.
no, Lord,
Yeah?
as early as possible, Lordship, kindly allow me at least 4 months' time, Your Lordship. Within that time, we will pay, Your Lordship.
This order was passed on
Yes, Your Lordship.
5/4.
Yes, yes.
What were you doing after that? This budget. Now the budget problem is because there was a vote of account. That is in this year, not last year.
Last year also there is positive fund, Your
There was a
Lordship.
direction why it was not complied with. Who is the authority who has to do it? Executive engineer, chief engineer.
Chief engineer, Your Lordship.
Why? Why was the chief engineer sitting over our orders?
No, Your Lordship, not sitting over, Your Lordship. Demand is placed, Your Lordship, but could not be processed, Your Lordship, because of.
When was the
positive
demand placed?
Demand was placed, Your Lordship, 14/10/25, Your Lordship.
And this order is 5/4. And the period of completion was 4 months.
Months, Your Lordship.
So 5/4, 5/8. Why another 2 months it took to start processing?
Maybe.
Why the order, when was this order served on him? When was this order served?
5/4, page 12.
21/7. Page 12.
Page 12 is order of the High Court in the petition.
No. When did you serve this order to the chief engineer?
Page 10.
On 21/7.
Lordship, kindly
So
allow.
he has done correctly. Within the period he has initiated. Now the money is not there, so you'll have to wait for some time. Miss R.M. Deka, learned counsel, who was learned standing counsel, Water Resources Department, who was requested by this court to receive instructions as to why the directions passed by this court wide order dated 5/4/2025 in WPC number 1205/2023 was not complied with by the respondents. Ms. Decca submits that the certified copy of the said order dated 5/4/2025 was served upon the respondent, upon the Chief Engineer, Water Resources Department on 21/7/2025, and thereafter on processing of the matter, the said authority had placed a demand for a release of the amount for payment of the bills of the petitioner. However, on account of the fact that there was no fund available, the bills of the petitioner could not be further processed. She submits that the bills of the petitioner, pending bills of the petitioner, shall be processed and cleared within a further period of 3 months from today. It is provided that no further adjournment shall be granted in the matter. Registry to list this matter again. On 2/9/2026. On the next date of listing, the incumbent in the post of Chief Engineer, Water Resources Department, including the respondent herein, the respondent herein, including or any other incumbent who would come into, who would be occupying the post of Chief Engineer, Water Resources Department, shall on the next date of listing, that is on 2/9/2025, place before this court the compliance report. Ms. Decca is requested to formally forward a copy of this order to the Chief Engineer, Water Resources Department for compliance. Wait for some time, you will get it. Why?
I received the affidavit recently, my lord. And by this affidavit, my lord, they brought some new facts, my lord, which are contradicts with my petition. So I need to communicate with the client, my lord, in this regard. Recently they filed, but I received on Friday, my lord. My petition based on documents. Now they are brought some new facts.
Oh, this was filed on
Recently, my lord.
19/5.
I received on my lord, this furnished on 25/5.
Maybe that is private respondent, man. Thereafter, private respondent have also filed, man.
But on 25/5 they filed, my lord.
Who?
Private respondent also filed, man.
When did you file?
Private respondent filed my 25/5. And I received, my lord, because on 25/5 I was not.
We forget the respond number, the
Private.
private respondents. We'll only go by the commented rate.
That is also I received, my lord. On 19/5 I did not.
Ah, 19/5 you received.
I did, my
Without serving a copy, I cannot file, man.
my lord, my clerk received it, my lord, on that.
Is that my mistake?
No, this is right, my lord. But now I
Your
I
clerk
have gone
receives,
through my.
you receive, whoever receives will receive. Nothing is here. All disputed questions of fact. We are not going to entertain this.
Since these are disputed questions, so my lord, I need to communicate with my client, my lord, in this way.
What more you will have to communicate?
Because that's
Each and every document of yours is being disputed. Plus, you are held to be not an employee of the Panchayat department. You go.
So these are the new facts, my lord, I have gone through, my lord.
I'm
Now,
sorry, these are not the new facts. These were facts already projected on 27/4/2026 before this court. 27/4, this was projected.
They did not file affidavit, my lord. They are just told, my lord.
But the Lana Council for the parties at some length. Registry to list this matter again on 15/6/2026. The petitioner is granted an opportunity to bring on record rejoinders to the affidavit filed by the state respondents as well as by the respond number 7. on or before 12/6/2026. No further adjournment shall be granted for filing of affidavits by the petitioner.
Obliged.
I love this. So why is all here today? Today is here, no? Then I'll go inside and do VC. That will be better.
Smile.
Where is the budget provision?
Lordship, I have obtained the my instructions, my lord. Lordship, it's quite a voluminous one. The first page, Lordship, will come,
So this is also now voluminous. Okay, fine.
but I'll break it up, my lord, because my lord,
Okay, let's see. Department reiterates so and so. Not
budget for
prepared.
irrigation department is not
Submit the
prepared by
budget
GAD, my lord.
so and so.
Irrigation department submits the budget estimate under the head of account 2052 so and so irrigation, my lord. Under grant number so and so to GAD, which is subsequently forwarded to finance department. Thereafter, the budget communicated by the finance department utilized by irrigation department through their own DDO.
Okay.
Now, my lord will kindly come to. I've got the full form and all, my lord. How the payments are made, my lord. Lordship will kindly come to the last page first, my lord. Last page. From the last page, Lordship will come to the one.
So this is not from the general budget of Secretariat
Yes,
Administration.
fifth last page, my lord. This is the, my lord, DDO. The DDO is Mr. Navakumar Mohanto. He is the undersecretary to the, my lord, irrigation department. Below your lordship will see irrigation department. To the treasury officer. The name of Upendas is there in seal number 2. The fifth last page, my lord. Have you lordship got it? That is the bill. This is for the month of this April. Latest month. April 4th, 2026.
So this is not in terms of that other SAD employees where one
my
bill go.
Absolutely no.
This is goes separately.
It goes from the irrigation, and my lord, Upendas, there are many other people. Upendas to my lord, his account number so and so, and my lord, this DDO is the irrigation department. It's given there on top. And this is the payment which has been made to him on April 2026. So automatically, my lord, that itself shows that the irrigation department is the concerned authority, and the SAD, my lord, as per rule.
And with regard to the other employees, it is SAD who does it.
My lord,
The other
one person, that Noor Ali, which he had shown that day, that one isolated person, my lord.
No. With regard to the other departments,
My lord.
you do it from the SAD itself.
Not all, my lord. They're the same way, my lord. The amount comes from the concerned department, say PWD, someone is from the PWD. The amount comes like how it's come here. DDO is the PWD. Not the, but if it is SAD, if it is a person who's appointed by the 2I, that is 2I of the Act, then it is the SAD.
So SAD employees are also posted to various departments.
But my lord, the ones who have been appointed by a deputy secretary from that same rules, my lord, the record suppliers rules, anybody who has been appointed by the SAD, that is a deputy secretary, and if there is no deputy secretary and under secretary, then it is comes under we are the ones who pay them directly.
Then you will become the DD.
Then we are the DD. So that is the thing. And my lord, the rule speaks for itself. And my lord, relying on that, my lord, I would also want to rely on one judgment, my lord, for this kind of thing, my lord, is that my lord, I have given the book list, my lord. Lordship will note down the citation, my lord. 98-8 SCC 469. My lord, if I may allowed read, my lord, rules, my lord, statutory rules, health cannot be overridden by executive orders or executive practice, my lord. Executive practice, my lord. They cannot override it. So this is Article 309 back rule, my lord.
That is settled position.
Yes, lordship.
Okay, 1998.
1998 8 SCC 469.
1998 8 SCC.
469. 1998 8 SCC 469 K Kupuswamy and another. And my lord, I'm also relying on paragraph, my lord, 3. I'm also relying on, my lord, 1993 Supply 3 SCC 575. There, this is a 3-judge bench, my lord, Constitution. Paragraph 33.
SCC.
1993 Supplementary 3 SCC 575. This is, my lord, paragraph 33. These are three,
What's
three
the
judgments.
name of the party?
The ratio in this case is,
The
my lord,
name of the party?
name of the party is Syed Rizvi.
Oh, sir, okay,
And
fine.
my lord, there, my lord, the ratio which is there, my lord, is
Fine,
appointment
fine,
to,
fine.
my lord, appointment, my lord. My lord.
Yes.
And my lord, one more I'm relying, statutory rules cannot be overridden by this thing, that is 98 SCC 469.
469 you have said.
Already said, my lord. And my lord, and 1992 supplementary 1 SCC 272, paragraph 33 again. This is
1992 supply.
1 SCC,
Ah,
page 272, paragraph 33. This is three judge, my lord, again, and the ratio is rules.
Name.
Name, my lord. Ratio is, my lord.
Name of the parties.
Name, I'll just say. My lord, Keshav Chandra Joshi. Keshav Chandra Joshi, my lord, and the ratio is, my lord, rules did not permit relaxation of recruitment rules.
Oh, that is done.
My lord.
All settled also.
And my lord, also, my lord, I would like to rely upon 1997 4 SCC 753. Paragraph 5. This is Division Bench Supreme Court, my lord.
4 SCC?
1997 4 SCC 753. Paragraph
Para?
5. This is, my lord, any past practice dehoes the rules cannot be taken into consideration as past practice consistently followed for a long period by interpreting the rules. When there is a rule, my lord, in place, they cannot override that. If there is no rule, then, my lord, they can take that, my lord, past practice. That, my lord, judgment was the N. Suresh Rathan case, which said that past practices can be allowed. But, my lord, here I'm relying on D. Stephen Joseph, which has
These are your favorite judgments.
My lord. So I'm just citing it.
Past practice should be followed.
Past practice should not be
These are
followed.
your favorite judgments.
My lord. So this is my lord,
Okay.
thing.
Mr. Narayan Upadhyay,
I have
Standing Council, Water Resources.
irrigation.
You have created a monster problem. Resolve it up to yourself. We are not putting the burden on the SAD.
Yes, lordship.
You cannot be promoted in the SAD service. You will be promoted. The irrigation wants to promote you somehow, they will do it. Or you give him ACPS.
We are giving, lordship. That is.
ACPS is
Yes.
Take us. Second half of Pasco. I'll just formulate it once and pass in the second half. And we are not referring to your judgments. These are settled positions of law. Delivery as no, submitting. Yeah. One item.
My lord. So
Yes, who is appearing for the respondents? Mr. Aramdas is not available in court today. He is the Standing Council Urban Water Research, or who is the Standing Council PHE? You are from PHE to...
I'm tested PHE to urban development.
Then you came back again.
UDD.
Then you came back.
Then came back. And UDD has regulars me. That's my prayer.
That much reading we do. We'll come to you. Yes, who is appearing for the PHE? Who is appearing for finance? Who is appearing for the other respondents? Madam, you are appearing for? Respond number 4. You are the arguing counsel. Then get your arguing counsel because I'm going to pass orders here now. Whoever your counsel is, get it. If he is on leg, let him continue on legs there. We'll pass orders.
One thing, my lord.
I've not seen him. Never. I don't know why. Is he having some adverse things to come to this court? I think so. Today I have not seen him. There were many matters. And who is appearing for PHE? PHE ka na kuna sir? Nayak. I got her court.
My rejoinder with me.
Tap to the court. Yes.
rejoinder affidavit, my lord, it says, when the RTA reply says that there is a documents, my lord, they cannot give, supply these documents. That is why my regularization is
Forget
done.
it. You are pre-1493.
That is correct.
You were
I have
on
counted,
a work charge basis in the PHE.
yes,
Thereafter, you were taken to
You-
the
urban development.
there. Maybe you were regularized, not regularized.
But
That is.
my lord, my humble submission is
Now
that
tell me, Mr.
there is a departmental proceeding, and my lord, the finance letter is also there. In my rejoinder affidavit, I have annexed the RTA reply.
You
So-
want regularization.
No, I don't want. I am regularized. I want a
You are
declaration.
regularized in the corporation, not
Not
in
corporation, not the department,
When-
urban development department.
a department. You are not. That is a sewerage board. You are.
No. Board has no power. Department, my lord, if
Come, show me.
my lord, page 33, kindly see annexer sheet. That is why I want declaration. My lord, it is an in-person of government letter.
We are not
UDD.
giving any credence to this.
Then my lord, page 53, kindly see.
Because when you were reverted back, you were accepted as what do you call that?
Work charge.
Work charge.
PS is nothing to do with my regularization.
Mr. Counsel, when did you come back to the department? When did you come back to the department?
2011.
11. When did you file this case?
My lord, I was given this.
Mr. Borua, please answer the question.
Yes,
When did you file? After 11 years?
my lord, 22, my lord. Correct.
After 11 years?
Yes.
And were you regularized in the department? Let's construe that you are a work charge employee.
2000,
Were you regularized? When were you regularized?
2006.
Huh?
2006.
Where is the regularization on?
My lord, page 33.
That is?
Page 33, annexer C of the.
That is, Mr. Counsel, the regularization in the board. When you came back in 2011 to the PHA department, you were a work charge employee. Yes or no?
My designation is work charge. By when I reverted.
Reverted.
My lord,
Mr. Borua,
if I read
you are a counsel of this court. Please be straightforward. We are trying to get you somewhere. Nothing adverse against you.
Yes.
Forget the regularization. When you came back, you continued as a work charge employee.
Yes, my lord.
They did not regularize your services.
Yes, my lord.
Then they say upendas.
My lord, in their representation, they themselves forwarded my name. That do with their regularization, my lord. That representation I have also annexed. They have taken steps, my lord. Now, UDD is the department who has conducted selection, and after
Okay,
recommendation.
only on that point you want to argue? Argue.
My lord, another thing, my lord.
Argue. I will not consider anything else. I'll only consider that whether your services was regularized as per page 33. That much only.
And then, my lord, page 53, kindly see my.
53.
My lord, UDD was made party. Now it is our housing and department, my lord.
Okay.
And 56, my lord, kindly see.
56. Okay.
56.
So 33, 53, 56. Ah.
53, 56, yes, says that finance has already given the concurrence. Now, if my regulation is hijacked by somewhere, that letter speaks everything. That is UDD, that letter. That is, they says 53, they says that we are not custodian or we cannot give you this letter. So, it speaks everything, my lord. Otherwise, that will be, my lord, there is a chance of miscarriage of justice, my lord.
So after you came back and you were continued as a work charge employee,
My name is also forwarded.
your services were never regularized. Now you have retired, right?
During,
Are you getting
when they
pension?
check, two retired, one is still working.
No. Are you getting pension?
No mention, my lord.
So you don't have a regularization
Yes,
as
my lord.
coding.
Yes, my lord.
Yes.
My lord, Upendas has been set aside, my lord.
Finished.
Right. Yes. But
So now give them everything in terms of Sukendu. Now it will not be Upen, it will be Sukendu. Give them everything.
but my lord, in that
He does
judgment-
not know about that. Maybe
Yes.
that is why he is not going there.
Yes.
I wanted to give him that much only.
But in that judgment, my lord, for work charge, Honorable Supreme Court
I'm
has
sorry,
Yes.
work charge. They said the plea number
Judgment kira lo yan.
Conclusion number page para 79. All regularized benefits from the earlier date, and if they have retired, notional regularization with consequential monetary benefits and areas from the relevant date until their superannuation from the for the purpose of recalculating pension, gratuity, and other terminal dues. So they are now entitled to everything.
Yes, but my lord, an exception to
That is just a clarificatory order. The second part of that order that you will find in paragraph 96.
96 and 97, man.
Because Upendas, they were covered. You were giving it because of that only they were not regularized. Now that bar is open.
Now, my lord, it has to be, my lord, freshly looked into without relying on
Freshly looked into now, orders of regularization has to be passed. Only thing to be looked into, whether they are prior to 1490. That's all.
1993.
1993. Within a period of 1 month, give them the benefits.
I would like to, my lord, seek fresh instructions, my lord,
What
because this is
instruction?
the
Supreme
new
Court
development.
has passed. Who will now give instruction about the Supreme?
Only on that aspect, whether from 1993 there was
1993, if they are serving,
yes, ma'am.
they get in.
Only that aspect, ma'am.
But the Learned Council for the parties at some length. Registry to list this matter again on Monday for further hearing. Mr.
My lord,
Orva, you are getting everything.
yes, I have brought.
Ah.
I'm sorry, your lordship. I'm deeply
You
obliged.
unnecessary place you go and make arguments. See, that is only a board. Board is not government.
My lord, yes, I am.
That regularization would be of no consequence. I'll tell you, give you an example. Subject, if you can think over something, give me. Say I sent you on deputation
My lord.
from PHC to the board. In PHC, you are, say, junior engineer. I sent you to the board as assistant engineer. You continue there for a long time. Right? And you get everything. They even may have promoted you to assistant executive engineer there. Now, when I revert you back, can you claim that status?
No, that's not. Yeah, my lord, subject to correction, my lord, they are transferred permanently, my lord, because of the case, again, reverted, but it's deputation word is not used, transferred permanently. That is my.
Transferred permanently,
My lord, I have
transferred not permanently. You are getting everything in terms of this.
Yes,
thing.
my lord.
So what more
I'm
is
sorry,
it?
my lord, I have now.
And I'll ensure it that you get it within a period of 1 month or so.
Obliged,
All
my
right.
lord, deeply obliged.
Clear, leave it. But the matter is pertaining to provincialization of service. And the petitioner lordship is,
The direction of this court, earlier round of litigation,
yes,
that the case has to be considered by the
Department of Education.
departmental committee, the district scrutiny committee. Till now, it has not been done.
The district scrutiny committee meeting was held several times.
2 times after the order.
Yes,
But in both the times, the matter was referred to the director.
director.
And the director is playing a very,
That is the
I don't know what role she is doing or what is happening.
And-
Just dilly-dallying the matter and then telling the government that, see, because the district scrutiny committee has not
recommended. So he has not
who
placed.
is appearing for the secondary education department? What is the stand of your director here?
The affidavit.
We have filed our affidavit here.
Take your affidavit.
Yes.
Come to
So, my lord, after filing the writ petition by the Azizur Rahman, it was Honorable Court has declared it is uncalled for. The director speaking order, earlier speaking
Come
order.
to para 5.
19/4/2020.
Mr. Sharma, come
Yes.
to para 5.
Yes.
1, 2, 3, 4, 5, 6 lines from bottom.
Yes.
Read that.
The district scrutiny committee and the state level scrutiny committee as constituted under section 13 of Assam Education Provincialization Services and Reorganization of Education Institution Act 2017 in each district and at the state level shall scrutinize service records and other related issues of the non-teaching staff of venture educational institution for the purpose of provincialization of the services under this act. The list of non-teaching staff whose services shall be provincialized under this act shall be finalized in the manner prescribed under the aforesaid act. As the district scrutiny committee Dorang did not recommend the name of petitioner, that is Azizur Rahman, hence the state level scrutiny committee could not recommend the name
That
of the
means
petitioners.
because the state district level did not scrutinize,
Yes.
so you are saying we can do nothing further.
Yes.
Now come to page 51.
And page 46 and 49 also. Is that?
Sorry, page 46, first one.
And page 49.
Have you got it? Come to page 48, top portion.
Madam, 46.
46 is the DSC meeting.
Yes.
18/11/2017. Come to
Yes.
48. 1, 2, 3, third line, right-hand side.
Yes.
The district scrutiny committee decided to refer the matter to DSC Assam for finalization of the same. Because there was some doubt. They send the matter to the DSC. Kindly give us your opinion. Then again come
Yes.
to page 49. 3/6/2019. Come to page 50.
Yes.
First, second paragraph. 1,
Yes.
2, 3, 4, 5, 6, 7, 8, 9 lines.
Yes.
The district scrutiny committee,
Yes.
right-hand side.
Yes. Decided to refer the matters.
DSC
to
for
the-
finalization of the same. Now, these two documents have reached you. Where is the decision taken by the DSC in the matter? Her earlier speaking order withdrawn. This court said uncalled for.
Yes.
That will be of no relevance. And why is she now saying this, making this statement? As DSC has not recommended, we can do nothing. What is there? What is she there for then? What is your director doing there then?
Your Honor, it is-
At 2 o'clock, I want this instruction. After these matters were referred, why no action was taken on the part of the DSC? 2000.
My lord, today is holiday, my lord.
Call her up. This is not done, Mr. Sharma. Two persons are fighting before us here. And you are sitting cool, tight there and just making a note That because there is no DSC how can the DSC recommend once the matter is referred to the director? Mr. Sharma,
Tomorrow, my lord.
Mr. Sharma, you Sharma, Learned Standing Council, Secondary Education Department, shall inform this court, shall apprise this court on the next date of listing as to the steps taken by the director, secondary education, after the district scrutiny committee, bracket secondary, comma, Darang, had referred the matter pertaining to appointment, provincialization of services of the petitioner, as well issue pertaining to provincialization of services of the petitioner and the respondent number 8 against the post of library assistant available in Bornoi
Senior secondary school.
Bornoi Senior Secondary School was forwarded to the Director, Secondary Education, Assam, for finalization. Can I लिख जाऊँ? Then I know probably लिखूँगा. Shall Mr. U. Sharma shall apprise this court in pursuance to the conclusions pertaining to conclusions reached by the DSC pertaining to the provincialization of services of the petitioner and the respondent number 8 against the post of library assistant available in Bornoi Senior Secondary School in terms of the meeting, minutes of the meeting held on 18/11/2017 and 3/6/2019. The matter being so placed before the director, Mr. Sharma shall also apprise this court as to why in para 5 of the affidavit filed by the director, a plea was taken as that to the effect that as the district scrutiny committee had not recommended the name of the petitioner, the state level scrutiny committee could not make further recommendation in the matter. Such statement is so made without there being a clarification given as to the decision required to be arrived at in the matter by the Director, Secondary Education on the issue involved being forwarded to it by the jurisdictional district scrutiny committee. Yeah, Monday? Monday? Monday, for further hearing.
Yes.
And what we tentatively, subject to this, what we tentatively feel is, we are permitting the provincialization of the petitioner. It will go ahead. If you have any grievance, you can approach the jurisdictional educational tribunal.
For the earlier inquiry report is concerned.
Forget the earlier inquiry report. That is gone with the.
No, there is one thing.
Mr. Counsel, your plea is that you were appointed as an LDA. Thereafter, you were asked to look after the charge of library assistant. There is no order brought on record or a decision of the school managing committee brought on record allowing you to hold the charge of library assistant.
In this regard,
Rightly, wrongly, there are communications orders appointing him.
my lord, only my submission is that in earlier round of
That is what I said. That material, that is a disputed material.
manipulation of record.
No, that is a disputed material.
That wasn't looked
You
after.
go before the tribunal, get it resolved there. Not here.
Because,
But in the meantime, we are permitting him to be provincialized, which will be subject naturally to any proceeding that you institute before the tribunal. Otherwise, we cannot take a conclusion here.
my lord, so far I am understanding, my lord, in the earlier round of litigation, when the order was passed, Director supposed to have.
And the earlier round of litigation, the order was, if you have any further grievance, go before the. We are only directing in his case that in view of the materials coming on record, his case will now be considered for the post against as library assistant. Matter will go ahead. You establish it before the tribunal, you get your orders. That much. Pass that order next day, Monday. But I want these instructions, Mr.
May it please your lordship.
Yes.
Lordship, on the last date, I had submitted the doctrine of legitimate expectation. I had submitted a case from Himachal Pradesh High Court regarding the doctrine of legitimate expectation. Lordship, the same was also put up in this Supreme Court judgment from 30 January, your lord.
Legitimate expectation, fine. But when the need is not there, how can that legitimate expectation continue?
Lordship, continued extension of services and prolonged, work, uninterrupted services has created this legitimate expectation of permanence, your lordship.
So we are going to break that legitimate expectation to.
Lordship, this the same was also taken up by the appellants in this Supreme Court judgment, your lordship, wherein it was also considered, your lordship.
Contractual appointment.
Lordship.
This also.
Lordship. Your lordship may find the doctrine of legitimate expectation in page 23 of the said judgment.
Anything more?
Lordship, in page 26 and.
Mr. Counsel, this is different.
Lordship.
This is different.
Lordship.
This is different. It's got Bolana will have no application for it. This is pure contractual and in a temporary organization. Yes, Mr. Bora.
There is a lordship judgment, my lord. Yes, Ali. It went to division bench, upheld, my lord.
And Mr. What is relevant here is they have not alleged any misconduct against you. No stigma. Work not required. That termination is simpliciter.
Lordship judgment in the SCC online. Thereafter, the writ appeal was filed, my lord. It was upheld.
What happened in the division bench?
It was upheld, my lord. Lordship order was upheld.
Think so. This was, I think, pending.
No, my lord. I have given the order, my lord.
Division bench.
Division bench.
Oh, this is division bench. Oh, sorry. I was reading like this when I saw this is my order only. Oh, the matter was taken to a different level altogether.
Paragraph 11, my lord.
Beautiful. one of the well-written judgments I've seen. Simple. You're really beautiful. I'll have to keep a copy of this. Chief. Sorry, next time. But Mr. I.S. Mazhar Bhuiyan, Learned Counsel for the Petitioner. Also heard Mr. S. Bora, Learned Standing Counsel, SSA. Have your seats, have your seats. The petitioner in the present writ petition has, by way of instituting the present writ petition, has presented a challenge to, has assailed an order dated 1/4/2025 issued by the Mission Director, SSA. No, Mission Director, Samagra Siksha, Ahum. Releasing the petitioner from her contractual services on the ground that her contract was not which had expired on 31/7/2024 was not renewed thereafter. Also, the petitioner, in pursuance to a process of selection, was appointed as a draftsman in the your such appointment earlier was maybe under that SSA. Draftsman in Rashtriya Madhyamik Shiksha Abhijan in the month of November 2011. The said Rashtriya Madhyamik Shiksha Abhijan was subsequently amalgamated with Sarva Shiksha Abhijan, and thereafter the organization was renamed as Samagra Shiksha Ahum. The petitioner projects that she continued in her services, and there was no orders issued extending her services and or agreements executed renewing her such contractual services. Accordingly, the petitioner projects that she was continuing in her services like any other regular employee in a government department. Also, the petitioner submits that poised thus the respondent authorities, without any prior intimation, proceeded to terminate the services of the petitioner by issuance of the order dated 1/4/2025 on the ground that the agreement executed between the organization and the petitioner had expired on 30/7/2024 and was not renewed thereafter. It was further projected that the services of the petitioner would no longer be required in the organization with effect from 2/4/2025. The learned accordingly, being aggrieved, the petitioner has instituted the present writ petition. The learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that since November 2011, the petitioner was continued in her appointment, continued as a draftsman in the Samagra Siksha Ahum, and she had discharged her duties without any blemish. It is submitted that the necessity for continuing with the services of the petitioner can be viewed from the fact that her such continuation on contractual basis was automatic with the authorization of annual increments to her. It is projected that there is no orders issued towards renewing the contractual appointment of the petitioner, extending the contractual appointment of the petitioner, and no agreement as otherwise is required to be so executed was required to be so executed by the petitioner. The learned counsel for the petitioner submits that the ouster of the petitioner was only with a view to appoint persons close to the powers, if that be against, for the works that the petitioner was discharging prior to being released from the organization, widely order dated 1/4/2025. Per contra, Mr. S. Bora, learned standing counsel, Samagra Siksha Abhija Ahom, has submitted that the services of the petitioner was being extended after fresh agreements in this connection were being executed between the petitioner and the authorities of the SSA. He submits that the last of such agreement was so executed with the petitioner for the period with effect from 1/9/2023 to 31/7/2024. Accordingly, it is submitted that the petitioner, by projecting that there was no agreement executed between her and the organization for extension of her services, had tried to misrepresent before this court. It is submitted that the petitioner's release from her services with the organization was on account of the fact that the work for which the petitioner was so engaged did not arise for execution any further, and accordingly there was no requirement for continued engagement of a draftsman in the SSA, and accordingly, basing on the conditions of the contract executed between the petitioner and the organization, the petitioner came to be released from her services. Mr. Bora submits that no stigma and no misconduct has been alleged against the petitioner in the order dated 1/4/2025, and accordingly, the said order being innocuous, being an order of simple termination of the services of the the same would not mandate any interference from. Rejoining his submissions, Mr. Borthaku, IS Mazhar Mian, learned counsel for the petitioner, submits that admits that the contract, insofar as the petitioner, a contract of the petitioner had expired on 31/7/2024. However, in the same breath, it is contended that the agreement brought on record as Annexure 1 to the affidavit filed by the respondents was not executed by the petitioner. Accordingly, it is submitted that the petitioner being continued with in her service since November 2011 with the payment of enhanced remunerations over the years, comma, the respondents without demonstrating as to why the services of the petitioner was not further required in the organization, comma, the order dated 1/4/2025, which is protected to be only in the nature of a camouflage, comma, would mandate an interference from this group. Right? Anything more? Now I can safely rely on my gear, Sally. এখানে কপি বাকি WPC 3949/2023. মাৰি দিবা খালি মাজত এটা পেৰাগ্ৰাফ থৈ দিবা তলত দুটা পেৰাগ্ৰাফ থৈ দিবা
Right, Your
dismiss stuff. Sorry, next time, better guess.
Lordship. Thank you.
Lordship says last occasion directed us to place the record, Lordship. Madam, may kindly come to page 27 of the 27 of the petition, Lordship. They have submitted a list, Lordship, whereby petitioners shown as Lordship qualified. Serial number 10, Lordship. But that list is not existence in our office.
We don't want that. But where is that 10-4 list?
Lost. That particular list, my lord, may kindly produce. That particular list. This is a list duly signed by the director, Lordship. And that particular list, there is no seal and signature, Lordship.
No, that was uploaded in the website now.
Where the petitioner's name was, Lordship, serial number 10, Lordship.
Sometimes you got to enjoy the other party's arguments also. Yes.
Serial number 10, Lordship. And it is in our record in page 186 and 187, Lordship. Today's
Okay, why is he underqualified there?
Lordship. Here only reason is that, Lordship, after 2007, in 10/7/2009, he was MPhil, Lordship. At the relevant point of time, Lordship, violating the provisions of the Act, Lordship, some persons are engaged, Lordship. That's why, Lordship, that new clauses there, Lordship, regarding, Lordship.
When was this list uploaded?
That part, Lordship, that is not there, Lordship. Otherwise, in the file, Lordship, page 186, today's holiday, that's why we are not able to bring the file, Lordship. 186
Okay, get the file.
Lordship, 186 and 187.
Let me get the file.
Lordship.
Because Mr. Chakoti, you have brought in a unqualified list also somewhere. Where is
Yes. That phase, my lord, 31, my lord. 31, annexure 9. Serial number 4, my lord, she gets in.
Just a moment. No, Sakera Khatun, Mundas don't get in.
No, my lord, Surishi Singh. Page 31, my lord.
Surishi Singh.
Yes. She is, of course, a different department.
Zoology,
Yes. But she gets in, despite being underqualified.
Surushi Singh, it here says that qualified, Lordship. that particular list, Lordship.
Surushi Singh has SLET qualification.
Late in 2012, Lordship, and she was shown as qualified, Lordship.
So let us get, let Mr.
Lordship.
Gogoi get the list. Fine. Now you have been regularized as tutor.
Tutor.
So that much only we got to examine. Mr. A. Gogoi, Learned Standing Council, Higher Education Department, submits that he be granted time till
Next week.
next week,
Lordship.
Tuesday,
Next Tuesday. Next Tuesday, Lordship.
on till 9/6/2026 to place on record the original records pertaining to the processing of the cases of teachers, teaching and non-teaching staff of
BS College Howley, Lordship.
PH College Howley for provincialization of their services under the provisions of the
2011 Amendment 2012, Lordship.
as amended.
Lordship.
Prayer accepted, registry to list this matter again on 9/6/2026.
Lordship. I'll
Just get that.
I'll place. Oblige, Lordship.
And Mr. Chakraborty, you also examine from your client, take instructions whether the other people who were there, who had got MPhil in 2009, whether that is before 1907 or after 1907. Even if it is before 1907, it is of no use. That MPhil cannot be
Cannot
taken
be
into
lost. That's why
consideration.
all the persons, Lordship, just to indicate all the persons who are Lordship, regularized at the relevant point of time, now all are under scrutiny, Lordship. And so cause was also issued to the persons, and so many cases also came up before your Lordship. That part, Lordship.
24.
Lordship.
That is different.
Lordship. Oblige.
Started taking issue. Yes. Anything more?
No.
Heard Mr. R. Chetri, Learned Counsel for the petition. Also heard Mr. A. Chakraborty, Learned Counsel, appearing for the respondents. Learned Government Advocate, appearing for all the respondents. The petitioner in the present writ petition has present a challenge to an order dated 25/4/2024, by which on conclusion of a departmental proceeding instituted against him, he was imposed with the penalty of dismissal from service. The petitioner while working as a unarmed branch police constable attached to the You were attached to the police reserve, Jorhat.
Police at Jorhat.
A police reserve, Jorhat, was placed under arrest in connection with on 6/11/2023 in connection with Jorhat PS case number 500/2023. The said case was registered basing on a FIR lodged by one Srishti D. Kashyap against the petitioner, alleging that she was molested by the petitioner. The petitioner, after his arrest, was sent to judicial custody by the trial court by order dated 7/11/2023. The petitioner having been placed under arrest, having continued detention for more than 48 hours, the petitioner was placed under suspension with effect from 10/11/2020 by issuance of a order dated 14/11/2020. So, and Mr. Chetri, you are assailing a disciplinary proceeding penalty. You have not brought the show cause. You have not brought the inquiry report. You have brought nothing.
Lordship, therefore, a report was called for. The department.
Oh, that is the headache of this court to call for, to and see. A record, please. Now the records are there, so we could understand. Okay. Don't be so casual. Bring that on record. Have a full-fledged challenge, then we will see what happens. So, the disciplinary authority of the petitioner issued to the petitioner show cause notice dated 22/11/2023, instituting a disciplinary proceeding against the petitioner. So, the allegation leveled against the petitioner in the said show cause notice pertains to the allegations leveled by said Srishti D. Kashyap. The petitioner thereafter submitted his show cause reply on 27/11/2023, denying the allegations as leveled against him. So, the disciplinary authority not being satisfied with the reply submitted by the petitioner in the matter, proceeded while order dated 5/12/2023 to direct for holding of an inquiry in the matter and for the purpose appointed an inquiry officer and a presenting officer. So, thereafter, an inquiry is found to have been held in the matter with regard to the charges framed against the petitioner while the show cause notice dated 22/11/2023. The petitioner is found to have participated in the inquiry and is also found to have cross-examined the witnesses deposing therein. On conclusion of the inquiry officer submitted his report and therein held the charges leveled against the petitioner to have been established. A copy of the inquiry report was forwarded to the petitioner by his disciplinary authority, wide communication dated 11/2/2024, requiring the petitioner to submit a representation thereon. The petitioner accordingly submitted his representation. Thereafter, the disciplinary authority, on consideration of the materials coming on record in the inquiry, the inquiry report, as well as the representation submitted by the petitioner, proceeded while order dated 25/4/2024 to hold that, to concur with the conclusions reached by the inquiry officer and to hold that the petitioner was guilty of the allegations leveled against him in the connected show cause. Accordingly, the petitioner was imposed with a major penalty of dismissal from service. The disciplinary authority further provided that the period the petitioner had remained in judicial custody, that is from 6/11/23 to 19/11, shall be treated as a leave without pay. And for the period of his suspension with effect from 20/11/23 to 23/4/2024, the petitioner shall be treated as on duty and he would be permitted to draw his salaries for the set period. Also, being aggrieved, the petitioner had assailed the said order dated 25/4/2024 by way of preferring an appeal. The appeal not being disposed of, the petitioner had approached this court by way of instituting the present writ petition assailing the order dated 5/4/2026. It is to be noted that during the pendency of the present writ petition, the appeal being disposed of, the petitioner has brought the order of the appellate authority on record by way of filing an additional appeal. Also, Mr. R. Chetri, learned counsel for the petitioner, by reiterating the facts noticed herein above, has at the outset submitted that copies of the show cause notice, show cause reply submitted by the petitioner, inquiry report, and the copy of the appeal so preferred by the petitioner were not brought on record, inasmuch as the petitioner's claim in the present writ petition is based on his acquittal from the criminal proceedings instituted against him, subsequently. It is projected that the petitioner, basing on the same allegations having also been proceeded against in a criminal proceeding and the said proceeding having resulted in his acquittal, the conclusions drawn by the disciplinary authority in the by the inquiry officer in the disciplinary inquiry, as well as the penalty imposed by the disciplinary authority while the impugned order dated so-and-so 25/4/2007 would mandate an interference from this court. 25/4/24 would mandate an interference from this court. In this connection, the learned counsel for the petitioner has placed reliance on the decision of the Honorable Supreme Court in the case of GM Tank versus State of Gujarat, reported in 2006, 5 SCC 446, and in the decision and the decision of two 2006 4 SCC 446, and the decision of the Supreme Court in the case of Ramlal versus, this I am adding for you, Ramlal versus State of Rajasthan and others, reported in 2024 1 SCC 175. So, in the above premises, Mr. Chetri submits that although he was held to, although the charges leveled against him was held to be established in the disciplinary proceeding, in the disciplinary inquiry held in the matter, the same would be of no consequence, and the acquittal of the petitioner in the criminal case would have to be given prominence, and accordingly, you have retired from your services.
No.
Accordingly, the petition would be entitled to be reinstated in his services with all consequential benefits. Mr. Chetri, by referring to the order dated, judgment and order dated 26/11/2024, passed by the learned trial court in PRC case number 130/2024, has contended that the learned trial court, basing on the materials coming on record, had concluded that no offense was made out against the accused under the sections of law he was charged against. It was further held by the learned trial, it was further projected that the learned trial court had also held that the informant had failed to implicate the petitioner herein. Accordingly, he submits that the same being a conclusion arrived at in the matter by the learned trial court after the trial of the matter had concluded, the same would have overriding effect over the conclusions drawn by the disciplinary authority in the disciplinary proceedings. So accordingly, Mr. Chetri reiterates his prayer that he should be permitted to be reinstated directed to be reinstated in his services. Per contra, Mr. A. Chakraborty, learned government advocate appearing for the respondents, has placed on record, has furnished the original records pertaining to the disciplinary proceeding instituted against the petition. By referring to the show cause notice dated 22/11/2023, Mr. Chakraborty submits that the allegation leveled against the petitioner pertained to his conduct as a member of a disciplined force in trying to take undue advantage, undue favor from the informant, from one Srishti D. Kashyap, in the guise of helping her. It is projected that Mr. Chakraborty commits that the petitioner, having found a lady in distress, ought to have forwarded her to the holding area and or to the police station under the custody of a lady constable. It is submitted that the petitioner had not even informed his superiors about the same, and the entire episode had taken place. And during the entire episode that had taken place, the petitioner continued to remain in his uniforms. Mr. Chakraborty further submits that the petitioner had exploited his position by taking benefit of his uniform and took advantage of a lady who confided in him about her distress. Mr. Chakraborty submits that the petitioner had taken the lady to a hospital, to a hotel, and therein had booked a room by introducing the lady to be his wife. He submits that the said aspects of the matter was established during the inquiry. By referring to the inquiry statements of the witnesses available in the record, Mr. Chakraborty has submitted that a perusal of the statements made by the victim girl as well as the statements made by the employees of the hotel wherein the petitioner had booked a room would go to reveal the malafide intention of the petitioner. He submits that the cross-examination, a perusal of the cross-examination part of the deposition made, the cross-examination of the victim girl made by the petitioner would go to reveal that the allegations as leveled in the allegations as leveled against the petitioner stood established, stood reaffirmed liquid. So accordingly, Mr. Chakraborty submits that the inquiry officer, strictly basing on the materials coming on record, had proceeded to hold that the charges framed against the petitioner stood established. Mr. Chakraborty submits that the disciplinary authority, after having received the representation against the inquiry report from the petitioner, had taken up the matter for final consideration, and while order dated 25/4/2024, had basing on the material and 25/4/2024 drawing satisfaction from the materials coming on record in the inquiry, imposed the penalty of dismissal from service upon the petitioner. Mr. Chakraborty submits that in view of the facts and circumstances of the matter, the penalty of dismissal from service is found to be proportionate to the allegations proved against the petitioner. Mr. Petri, last lawyer, has further submitted that the penalty of dismissal from service as imposed upon the petitioner is clearly disproportionate to the charges proved against the petitioner in the inquiry. In the above premises, Mr. Chakraborty submits that the subsequent acquittal of the petitioner in the criminal proceedings instituted against him would be of no consequence, and the order of dismissal imposed upon the petitioner would not mandate an interference from this court. I've heard the learned counsel for the parties and also peruse the materials available on record. At the outset, this court notices that the learned counsel for the petitioner has not pointed out any infirmity that may exist in the conduct of the disciplinary proceedings against the petitioner hearing. The learned counsel for the petitioner has further not projected any prejudice being caused to the petitioner during the conduct of the disciplinary proceedings against him. It is a settled position of law that the scope of a judicial review in a departmental inquiry matter is very limited. This court can interfere with the disciplinary proceeding only if it is so demonstrated that the proceedings were conducted contrary to the well-established principles of law, or the conclusions drawn by the inquiry officer and or the disciplinary authority was so drawn basing on no evidence, or where the very competence of the authority instituting such proceeding has been challenged. In the present case, no such contention has been raised by the learned counsel for the petitioner. However, with a view to satisfy, however, this court with a view to satisfy itself had perused the materials available in the original records of the inquiry as furnished by the government advocate. On a perusal of the statement made therein by the victim, this court finds that in her statement, she had brought on record materials to establish the allegations leveled against the petitioner in the show cause notice. However, what is interesting to be noted is that during her cross-examination by the petition, the allegation level against the petitioner got solidified. From the cross-examination of the victim girl, it is clear that examination of the victim girl, it is seen that she had contended during the at the hotel reception as during the hotel reception, family will the victim girl stated that the petitioner had outside the hotel required her to introduce herself as a family member of the petitioner. Further, she deposed that after entering the hotel room, the petitioner had locked the room from inside. Also, the said aspects of the matter was further fortified from the statement of PW5 and PW6, who were employees of the hotel and available at the time when the petitioner along with the victim girl had gone there. PW5, Roman 5, Roman 5, Roman 6, had confirmed that the petitioner had informed, had introduced the victim girl as his wife. So the above aspect of the matter clearly brings to the forefront the malafide intention of the petitioner and that he had sought to take advantage of a lady in distress. Accordingly, this court is of the considered view that the findings recorded by the inquiry officer in his inquiry report being found to be so based strictly on the materials coming on record in the inquiry, the conclusions drawn by the inquiry officer in the considered view of this court would not mandate any interference. Similarly, the disciplinary authority, for the purpose of passing the impugned, for the purpose of imposing the penalty of dismissal from service upon the petitioner, having agreed with the conclusions reached by the inquiry officer, this court is of the considered view that the said order dated 1/4 dated Kimanosil celebration would not mandate an interference on this count. Also, chance to make put Corona line third paragraph more submission. I have heard the learner counsel for the parties of first, second, third. The allegation level framed against the petitioner, why the show cause notice dated so and so being relevant is extracted here in below. Page 17 of Pavi. Yet more good. See envelope. Gateway. Also, the above conclusions having been drawn, this court would now examine the contention of the petitioner, learned counsel for the petitioner, that the petitioner having been acquitted from the criminal proceedings so instituted against him, comma, the criminal proceeding and the disciplinary proceeding being based on the same materials and witnesses being also common. The order of penalty of dismissal from service as imposed upon the petitioner in the departmental proceeding would mandate an interference from this court in view of the decision of the trial court to acquit the petitioners from the criminal charges framed against him. The learned counsel for the petitioner had in this connection relied on the decision of the Honorable Supreme Court in the case of GN Tank Supra. A2, A2A. Applying the decisions of the Honorable Supreme Court in the case of GM Tank and Ramlal Supra to the facts of the present case, it is seen that during the trial of the criminal case so instituted against the petitioner, only also and further as contended by the petitioner in the present writ petition, the trial court had only examined, the prosecution had only examined the victim girl and it is found that after examination of the victim girl, the prosecution case was closed. From the judgment of the trial court, it is found that the trial court had found that the victim girl, after having corroborated the averments made by her in the Ezahar, during her cross-examination had deposed that the petitioner herein had come to help her as she was loitering around Borua Sariali. The learned trial court accordingly held that from the deposition of the victim girl, who had also refused to lead evidence against the accused in support of the Ezahar lodged in this case by her, no offense was made out against the accused with regard to the sections he was charged under. This court finds from the materials coming on record that in the trial, the prosecution had not even examined the investigating officer of the case. Accordingly, the learned trial court had come to a conclusion that the materials available on record has failed to implicate the petitioner of having committed an offense under section 341/342/354/354B of the IPC. And proceeded to acquit the petitioner. A perusal of the judgment and order passed by the learned trial court would reveal that the same was so passed after the matter was contested in the manner required by the prosecution and was also cannot be said to be acquitted directed after all the relevant evidences in the matter was considered by the trial court. So, the Honorable Supreme Court in the case of GM Tank so accordingly, it is found that the acquittal of the petitioner is not in pursuance to a hot and contested trial. Accordingly, such acquittal, more so given the materials coming on record during the departmental inquiry, cannot override the penalty of dismissal from service imposed upon the petitioner. So, for the foregoing reasons, this court is of the considered view that the penalty of dismissal from service as imposed upon the petitioner would not mandate an interference from this court. Accordingly, the said penalty along with the order passed by the appellate order dated 28/5/2024 passed by the appellate authority stand affirmed. The writ petition is held next to be devoid of any merit and accordingly same stands dismissed. However, there would be no order as to the records produced by produced by Mr. A. Chakraborty be returned. আৰু কি আছে admissions আছে ন মই order to এটা তাৰ পিছত আৰু এটা কৰিম বুলি কৈছো এইটো হ'ব ঠিক আছে এইটো চাম কি open dust এইটো মোক অলপ ভিতৰত দি দিব আছে registry to list this matter again कितना दिया है 19/6/2026 now there is a demarcation and the land is found to be municipal corporation now you want it under the village so that that man will come under the panchayat and the panchayat can make the requisite notices see
The non-payment of some outstanding amount out of supply of some sanitizers during COVID period.
The affidavit?
No one.
Lordship, instructions are still awaited.
Huh?
Instructions are awaited, Your Lordship.
Awaited. When was notices issued? 24/3. Why? Why no instructions, madam?
Lordship, still awaited. Your Lordship may kindly grant us another 3 weeks' time.
3 weeks is nothing. If you have not been able to do it for 2 months, what will you do in 3 months? 3 weeks. Who is the authority who is not giving you instructions?
Lordship, it's supposed to be the Karbi Anglong
Huh?
Autonomous Council. The
Secretary,
Yes, Your Lordship, actually,
ask him to be here. Online, if required. We'll consult. Why the instructions are not coming? Small matters.
Lordship, this matter was supposed to be taken up by a VC, but there seems to be a problem with
Who wanted to come down?
my senior, Mr. J. Chutiala, Your
Or
Lordship.
Mr. Chutia? On the prayer is made on behalf of Mr. J. Chutia, learned counsel for the petitioner for an adjournment in the matter. Prayer accepted. The registry to list this matter again on 16/6/2026. By the next date of listing, the AAAC authorities shall invariably file their affidavit dealing with the claim made by the petitioner in the present writ petition. In the event the affidavit is not so filed, this court would consider passing or directions requiring the presence of the, who would be the competent authority?
Principal Secretary.
Secretary, Principal Secretary.
Respondent number.
Presence of the principal secretary. Government of Assam. Oh, no, that is for the government of Assam.
No,
Secretary.
Yes.
Secretary, Department of Health and Family Welfare.
But here, perhaps respondent number 7, Karbi Anglong Autonomous Council, represented by Principal Secretary.
Secretary, Department of Health and Family Welfare, Karbi Anglong Autonomous Council, respondent number 3, and
Respondent 7.
the newly implemented along with the Principal Secretary, Karbi Anglong Autonomous Council, on a date to be fixed with it, along with the contemporaneous records to assist this court in disposal of the present writ petition.
Obligation.
In this matter, what instruction do you have get, my lord? The petitioner was asked to submit all the bill and vouchers in 2025, 27. So as such, it was not disbursed, my lord.
You deny it. You file an affidavit that there is, with the matter we have, there is nothing. Deny it.
My lord, well, then we will file affidavit.
File affidavit. Why, if he is not submitting, who are we to ask them to submit? It's for them. They want to submit or not. But if they have submitted and you have not processed, that will be a different question altogether. So let us know that we don't have any bill. We don't have any document. Then dismiss the writ petition. That's all. On the prayer of Mr. G. Boklia, learned counsel for the government advocate appearing for the respondents, registry to list this matter again on 22/6/2026. The affidavit on behalf of the respondent be invariably brought on record on or before 19/6/2026. Yeah. Dictation room. But Mr. ABT Hoffman, line at counsel for the petitioner. Also heard Mr. N. I am for 3 parents. Heard Mr. N. Upadhyay, Standing Counsel, Irrigation Department, appearing for the respondents number 1. For the respond number 1. And Mr.
I've
A.
got
Pukan,
2, 3, and 4 minutes.
Standing Counsel, Secretariat Administration bracket Nazarat, or the Secretariat Administration Department. For the Secretariat Administration, appearing for the respond number 2, 3, and 4. Yes, have your seats, have your seats. The Petitioner, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities to consider his case for promotion to the cadre of a cadre of a lower division assistant, a cadre of junior administrative assistant in the Secretariat Administration Service. Your prayer has not been rejected till now. Also, as projected in the writ petition, the petition was initially temporarily appointed against a grade 4 post in the Secretariat Irrigation Department and was also attached a scale of pay. Also, the petitioner thereafter continued against the said post. Also, it is projected that although vacancies were available, it is further projected that the petitioner, during the course of his service in the year 2017, had acquired his degree qualification, that is, Bachelor of Arts degree from Krishna Kanto and Pandikoi State Open University. Also, the petitioner projects that in terms of the rules holding the field, he had acquired the requisite eligibility criteria for being considered for promotion to the post of junior administrative assistant existing in the Secretariat Administration Service. Assam Secretariat Subordinate Service. Also, the petitioner submits that although considering the date of his initial engagement, appointment as a grade 4 employee in the Secretariat, the petitioner had also would also come within the zone of consideration for such promotion. The case, the petitioner, although having approached, the petitioner had approached the respondent authorities for consideration of his case for promotion to the cadre of junior administrative assistant. However, such prayer not being considered, the petitioner has instituted the present writ petition with praying for the reliefs as noticed herein above. Mr. ABT Haq, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that in terms of the provisions of the Assam Secretariat Subordinate Service Rules 1963, the post of junior assistant, a recruitment to the post of junior assistant is to be made both by way of direct recruitment and also by way of promotion. He submits that It's that promotion would also be permissible to the extent of 10% of the vacancies arising in the cadre of LD, junior assistant from the incumbents in the grade 4 cadre. The petitioner submits that the criteria for such promotion is seniority. For such promotion is seniority. Just check up the criteria and the rules of seniority. Also, the petitioner accordingly submits that he, huh? Huh? Where do I get it?
Page 4 of Lordship, the Assam Secretariat Grade 4 and Record
which
Supply
rule?
Service Rules.
Which rule?
Assam Secretariat Grade 4 and Record Supply
No,
Service.
that is for the grade 4. I want the promotion to the, that is under the subordinate rules.
Oh, great.
How is the post of by selection? Selection means what? Also, Mr. Hawk submits that the respondent authorities in the present writ petition have taken Mr. Hawk submits that while the appointment and the continuance in service by the petitioner is admitted to by the respondents in the irrigation department, comma, the respondents in the Secretariat Administration Department, comma, in the present writ petition have taken a plea that the petitioner not being appointed to the Secretariat Administration Service, comma, his case for promotion, promotion to the post of senior assistant falling within the Assam's
Secretariat Grade 4 and Record Supply Service Rules.
Assam, no. Assam Secretariat subordinate service would not be mandated. Mr. Hawk submits that the said plea taken by the respondents in the Secretariat Administration Department is clearly perverse inasmuch as the petitioner is duly continuing in his services in the Secretariat and in terms of the Assam Secretariat Grade 4 and Record Suppliers Service Rules, 1963, the Secretariat has been defined to mean all departments of the Government Secretariat, including Chief Minister's Secretariat, but excluding the PWD Secretariat. He submits that the Irrigation Department, after it was so set up, having not been excluded from the definition of a department forming the part of the Assam Secretariat, comma, the employees in the subordinate service of the Irrigation Department cannot be held to be not also part of the Secretariat service. Assam Secretariat, Grade 4 and Registered Suppliers Service.
Record supplies.
Record Suppliers Service. Also, accordingly, Mr. Hawk submits that the non-consideration of the case of the petitioner for promotion to the next higher grade of to the cadre of lower division assistant has the effect of infringing upon his fundamental right vested in him for such consideration. Also, Mr. Hawk has submitted that in the above premises, Mr. Hawk submits that this court would be pleased to direct the respondent authorities, more particularly the Secretariat Administration Department, respondents in the Secretariat Administration Department, to consider the case of the petitioner for promotion to the post of Junior Administrative Assistant figuring in the Secretariat service. That much only, anything more, Mr. N. Upadhyay, Learned Standing Counsel, Irrigation Department, while admitting the fact that the petitioner was so appointed by the Irrigation Department and was continued in the services in the Irrigation Department, submits that the petitioner must be also deemed to be a member of the Assam Secretariat Grade 4 and Record Suppliers Service. He submits that only on account of the fact that the petitioner was initially appointed by an official of the Irrigation Department, the petitioner cannot be held to not also figure in the Secretariat service, more so when such appointment of the petitioner was within the Secretariat itself. He further submits that the pay of the petitioner is released by the drawing and disbursing officer in the Secretariat Irrigation Department after the budget provision for the same is so received from the Secretariat Administration Department, right?
This is the instruction.
Also, accordingly, he submits that there being no post available, post of the Junior Administrative Assistant and or any other grade 3 post, vacant grade 3 post available in the Secretariat, in the Irrigation Department, Secretariat Irrigation Department, the case of the petitioner must necessarily be considered for promotion to the cadre of Junior Administrative Assistant by effecting such promotion against any vacant post of lower division assistant forming the service Assam Secretariat Subordinate Service. Per contra, Mr. A. Fukan, Learned Counsel for the Standing Counsel, Secretariat Administration Department, at the outset by referring to the Assam Secretariat Grade 4 and Record Suppliers Service Rules 1963 has submitted that a person can be deemed to be a member of the service covered by the rules of 1963, provided he has been appointed by the Deputy Secretary to the Government of Assam in the Secretariat Administration Department. He submits that although the Assam Secretariat is projected in the rules to mean all departments of the Government Secretariat, including the Chief Minister's Secretariat, he submits that the commonality of the departments, he submits that the amalgamation of the departments to form the Assam Secretariat would not automatically mean that any member appointed dehouse the provisions of the said rules of 1963 would also be deemed to be a member of the service covered by the rules of said rules of 1963. Mr. Pukon, basing on specific instructions received by him from the respondents in the Secretariat Administration Department, has submitted that the petitioner was not appointed, was not recruited to his service by the authorities in the Secretariat Administration Department, and his such appointment was also not made in terms of the provisions of the said rules of 1963. Also, Mr. Pukon has submitted that the appointment of the recruitment of the petitioner was made solely by the Irrigation Department without any reference to the Secretariat Administration Department. Mr. Pukon has further submitted that the pay and allowances of the petitioner are drawn directly by the drawing and disbursing officer in the Secretariat Irrigation Department, and the same has got no connection with the Secretariat Administration Department. He submits that for employees forming the the service of the Assam Secretariat, the pay and their pay and allowances are drawn and disbursed by the drawing and disbursing officer in the Secretariat Administration Department. He has been given ACP.
Lordship, and in fact, he has been promoted to the post of doctorate as per the rules. He is
Who promoted?
Lordship Irrigation Department.
This is the grade.
Within
post
grade
promotional.
within grade 4 there is a post.
What difference does it make?
Same grade.
Left some salary.
Mr. Pukon submits that the manner of recruitment to the post of LDA, LDA, no, the junior administrative assistant, having been prescribed under the provisions of the Assam
Right of Lordship.
Under the provisions of the Assam Secretariat Subordinate Service Rules 1963 and the said rules
Rule 8.3.
having mandated that such recruitment is also to be made from the grateful staff and record suppliers of the Secretariat, he submits that the person in the feeder cadre can only be the person who was recruited in accordance with the provisions of the Assam Secretariat Grateful and Record Suppliers Service Rules 1963. He submits that the petitioner not having been recruited under the provisions of the said subordinate rules of 1963, he cannot be held to be placed in the feeder cadre for promotion to the cadre of junior administrative assistant forming part of the Assam Secretariat Subordinate Service and covered by the Assam Secretariat Subordinate Service Rules 1963. In the above premises, Mr. Phukan submits that the claim made by the petition present a writ petition not mandate. Hey, Mr. N. Upadhyay has submitted that the irrigation department in the meantime has already extended to the petitioner his financial upgradation under the MACP scheme as formulated by the government of Assam. I've heard the learned counsel for the parties and also perused the materials available on record. The petitioner admittedly was appointed against a grade 4 post in the Secretariat Irrigation Department, wide an order dated 23/2/1989, issued by the Under Secretary to the Government of Assam Irrigation Department. The claim made by the petitioner in the present writ petition is to the effect that he, having completed more than 7 years of service, continuous service, and also having acquired the graduate qualification, he is eligible under the provisions of the Assam Secretariat Subordinate Service Rules 1963 for promotion to the cadre of lower division assistant, junior administrative assistant. Rule 8 prescribes the manner of recruitment to the cadre of junior administrative assistant. Rule 8(1)(3) mandates that such recruitment by way of promotion is also permissible by selection from amongst the grateful staff and record suppliers of the Secretariat who have acquired the requisite qualification and have completed at least 7 years of continuous service in the Secretariat on the first day of the year in which the selection is being made. The promotion by way of selection from the cadre of grateful staff and record suppliers is to the extent of 10% in the cadre of junior administrative assistant. A perusal full stop. Rule 8(1) bracketed 3 prescribes the feeder cadre to be the cadre of grade apostrophe grade 4 staff and record suppliers. The recruitment to the feeder cadre, that is the cadre of grade 4 staff and record suppliers, is governed by the provisions of the Assam Secretariat grade 4 and record suppliers service rules 1963. Rule 2 bracketed Roman I defines the appointing authority to be the Deputy Secretary to the Government of Assam in the Secretariat Administration Department. Rule 6 mandates the provision for recruitment by provision for direct recruitment to the posts forming the grade to various grade 4 as well as record grade 4 cadre. Having noticed the provisions of the rules holding the field, this court would now examine the manner in which the petitioner herein was so recruited. As noticed herein above, the petitioner was appointed by the office order dated 23/2/1989 in the Secretariat Irrigation Department by the Undersecretary to the Government of Assam Irrigation Department. There is no material brought on record to demonstrate that the initial recruitment of the petitioner was so made in compliance with the provisions of Rule 6 of the Assam Secretariat Grade 4 and Record Suppliers Service Rules 1963, and that his appointment was so made by an authority in the Secretariat Administration Department. Admittedly, the petitioner was not so appointed in terms of the provisions of the Assam Secretariat Grade 4 and Record Suppliers Service Rules 1963. The feeder cadre for promotion to the cadre of junior administrative assistant in terms of the provisions of the Assam Secretariat Subordinate Service Rules, 1963, being the cadre of grade 4 and record suppliers of the Secretariat, the petitioner is not found to be a member of the said service, and accordingly, the petitioner cannot claim for promotion to the post of junior administrative assistant covered by the provisions of the Assam Secretariat Subordinate Service Rules 1963. The mere placement of the petitioner in the Assam Secretariat would not clothe the petitioner, would not also lead to the petitioner being included as a member of the Assam Secretariat Grade 4 and Registered Record Suppliers Service. Also, this court, having found the petitioner to be not placed in the feeder cadre for promotion to the post of junior administrative assistant in the Secretariat Administration Service, the claim made by the petitioner for a direction upon the respondent authorities for considering his case for promotion would not mandate an acceptance by this court. It is found that the petitioner being limited petitioner's appointment being limited to that of the Secretariat Irrigation Department. It is for the authorities of the Secretariat Irrigation Department to take appropriate steps for extending to the petitioner his service benefits. It is stated at the that the petitioner was extended with the benefits under the Modified Assured Career Progression Scheme by the Secretariat Irrigation Department. It is from this court, while not accepting the claims made by the petitioner in the present petition for a direction for consideration of his case for promotion against a post of junior administrative assistant figuring within the Assam Secretariat subordinate service, this court provides that in the event of any such vacancy occasioning within the Secretariat Irrigation Department, the case of the petitioner, the petitioner would be entitled to have his case considered for promotion against it is provided that any such vacancies in grade 3 occasioning within the Secretariat Irrigation Department, not covered by the Assam Secretariat Subordinate Service, the case of the petitioner be considered against such post, provided he has the requisite qualification for the same. The said direction would be not construed to mean that the petitioner would be entitled to be considered against a post within the Secretariat Irrigation Department and or any other department in the Secretariat covered by the provisions of the Assam Secretariat Subordinate Service Rules 1963. Such consideration as directed by this court is only to a post which figures within the Secretariat Irrigation Department and not covered by the provisions of the Assam Secretariat Subordinate Service Rules 1963.
And and also the record suppliers.
Oh, I'm grade 4 post comes under this, madam.
Okay, madam.
Sir, not under that.
That one.
Dispose of. Sorry, Mr. Hawk. Sorry.
There is no post in the irrigation department.
Oh, that is your headache. That is a balm that I have put.
There is no post.
So that at least I feel good.
Well, deeply obliged.
This one's okay, no?
Lordship, here in this case, Lordship, so far the notice issued, Lordship, but extra copy not received, Lordship. Although the notice issued in the last date, Lordship, but extra copy not received.
None appears for the petitioner on call. This court had issued notices on 24/4/2026. Mr. J.K. Goswami, government advocate, had accepted notice on behalf of respondent number 1 and 2.
Yes, 1 and 2.
And Mr. 1 and 2. 1 and 2.
As a standing counsel, Lordship.
Mr. J.K. Goswami, learned standing counsel, Animal Husbandry and Veterinary Department had accepted notices on behalf of 1 and 2. While Mr. S.R. Borua, had accepted notice on behalf of respondent number 3. It is submitted that the petitioner has not furnished extra copies of the petition, although the direction was that such extra copies be furnished during the course of the day. Also, it is foreseen further that this court, while order dated 24/4/2026, had also permitted the petitioner to rectify certain mistakes occasioning in the synopsis and thereafter to file a fresh synopsis in the matter. It is seen that that fresh synopsis has also not been filed. Also, considering that there is no representation on behalf of the petitioner, this court refrains from Also, the learned counsel for the petitioner is directed to comply with the directions passed while order dated 24/4/2026, including the direction to serve extra copies upon the learned counsel for the respondents within 3 working days from today. Registry to list this matter again on (17/6/2026). Mr. Goswami shall, before the next date of listing, file an affidavit to place on record the stand of the respondents represented by him as to why the petitioner has not been provided with the certificates in question.
The petitioner is entitled to a sum of rupees 3,85,014 only. 10% of the works done under Assam Electronics Development Corporation Limited. Mtron.
Who is appearing for the respondents? Nobody has appeared. Mr. Counsel, nobody has appeared for the respondents. This was a presumed service. Without their thing, how can we pass an order? If we pass an order, what would be the use of that order? You do one thing, serve, dusty, come back. It is seen that although the notices upon the respondent number 1 and 2 have been shown to have been issued to the respondent number 1 and 2 have been shown to have been delivered, there is no representation on behalf of the said respondents. Mr. D.K. Jain, learned counsel for the petitioner, submits that he would effect fresh service of notice upon the respondent number 1 and 2 by way of dusty. So, pre-accepted. The petitioner to take steps for service of notice upon respondent number 1 and 2 by way of dusty mode, routed through the registry of this court. Steps within 2 working days.
4 days.
1 week.
4 weeks.
Steps within 1 week. On affecting service of notice upon the respondent number 1 and 2 by way of dusty mode, petitioner to file an affidavit in the present matter. Registry to list this matter again after 3 weeks from registry to list this matter again on 19/6/2026.
Public.
Contractual bill, Lordship. They have filed a
affidavit, admittedly Lordship.
What is the admitted amount?
Lordship, 67 page 48 of my affidavit, Lordship.
69
Paragraph 17.
76,577 Lord.
They have not admitted.
Paragraph
Admitted,
17 of the
Paragraph 17 Lord.
affidavit, Lordship, page 48.
He says this is beyond your jurisdiction.
No,
No, Lordship.
the answering respondent stated the allegation regarding
You mean
refusal.
to say that this amount you are accepting? Mr. N. Upadhyay, learned counsel for the petition, for the respondent. Submits, the petitioner, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities to pay to him his outstanding contractual dues amounting to rupees 69,76,577 words of legally in connection with the works allotted to him by the respondent authorities. The learned counsel for the petitioner submits that the said amount is an admitted amount, and the petitioner submits that the petitioner, having successfully completed the works allotted to him, the said outstanding contractual dues of the petitioner is an admitted one. Also, accordingly, he submits that a direction be passed upon the respondent authorities to release the said amount of rupees so and so. Also, per contra, Mr. N. Upadhyay, learned counsel for the petitioner, of a learned standing counsel, irrigation department, submits that it is an admitted position that the petitioner is to receive an amount of rupees 69,76,577. However, the said amount could not be released to the petitioner for want of funds. I've heard the learned counsel for the petition for the parties and also perused the materials available on record. In the affidavit filed
By the chief engineer, page 48, Lordship, paragraph 17.
filed by the chief engineer, irrigation department, it is found that the following contentions have been raised. Para 12,
15 and 17.
17. Although this court had found the admission of the contractual dues by the petitioner, by the department in the affidavit, in the above noted paragraphs to be confusing. However, the categorical submissions made by Mr. N. Upadhyay, learned standing counsel, irrigation, that the said amount is an admitted due receivable, is an admitted outstanding dues receivable by the petitioner, this court proceeds to accept the said position. So, Amar je last order to you in view of the above, Tini Maha Bitot, Chief Engineer retired. Mr. Upadhyay, I
No,
hope
there
you
is-
have heard what I have said.
Lordship, I heard, but the instruction is
It
very
is
clear.
admitted, but the
Yes, my understanding.
refusal of
Tomorrow, don't come up with a review. It
No.
will be not less than 5 lakhs rupees. Personally on the advocate also.
They have said admitted amount. That is
I was dictating very slowly. Not that you may have something to say. You have nothing to
Lordship,
say.
it is admitted, but the refusal of
I said
Lordship.
confusing. I said confusing.
language is such, Lord.
I said confusing. If it was to me, I would not. But when he makes such categorical submission, who am I?
Admitted, Lordship, admitted.
Don't come back with a review.
Lordship.
You will be in trouble.
Lordship.
Yes.
May it please your lordship. Lordship, on last date, my lord, some instructions sought for, my lord. Now, my lord, the instruction I have received that we have decided to cancel the tender process, my lord. In view of, my lord, the expiry of validity of the tender, as your lordship finds that.
File an affidavit.
Lordship.
Bring this on record so that he can get a chance to.
I'll challenge it.
Miss P. Chakraborty, Learned. Standing Council, Irrigation Department submits that.
Oh, yeah, water resource, my lord.
Water Resources Department submits that. It has been decided to cancel the tender with regard to, never mind, owing to the expiry of the bid validity period. Are you ready to extend your bid validity period?
Here, my lord.
Are you ready to extend your bid validity period?
Yes, my lord.
Okay.
My lord, what
Miss
happened? Just
Chakraborty shall bring the said notification, the notice issued in this connection by way of filing an affidavit on or before 10/6/2026.
Well, there is an interim order operating. So if the department, my lord, goes for a. fresh
Interim
tender,
order
that
passed
promote-
earlier to continue till the next date of this.
My lord, that
You
should
bring
not
it
be-
on record. He should know. You can't do everything in your own in-house system.
my lord, here just
My lord, what happened?
23/2/2026, my lord, the finance bid was opened. They kept pending, my lord. In fact,
Today,
all other works.
today, Mr. Hawk, the bid validity that you had given, 120, 180 days, that is not there. So if you accept to do the work at that rate today,
Yes.
he is accepting. What do you say? Mr. Hawk, Learned Counsel for the petitioner has submitted that.
Petition is ready to.
A petitioner is ready to do the work at the rates quoted by him in his bid, and for the purpose to also further extend the bid validity period.
My lord.
Ms. Chakraborty shall also incorporate in the affidavit that is to be filed the stand of the respondent authorities with regard to the contention of the petitioner recorded above.
My lord.
But he'll do it in the old rate only. You have not said he is not qualified. You have only said
that
the bid.
He is
validity-
L1. There is no doubt about it. Only thing now.
Have you given him an offer that we want to extend it?
No, not yet.
Then why?
My
How
lord,
can
what
you
has
cancel
happened-
when that?
No, my lord, what has happened, after opening of that bid, my lord, that the election code of conduct was imposed. Therefore, no decision could be taken.
That is,
And
many
now, my
bids
lord,
are like that.
Yes,
You can
well,
ask for an
no,
extension.
uh,
Bid validity period extension is a known process.
my lord,
Do it.
will file a affidavit.
Mr. Das, we sometimes feel so bad not seeing you. And when there are 5, 6 matters together, not seeing you, we get an impression that maybe you don't want to come to this court.
No. I am there only.
Because you're these juniors who come, I have to keep my mouth shut because I know they will not be knowing anything. So the delay is occasioning in disposal of cases. If you are there, we can do something. But I don't find you, only your juniors keep on appearing. Creates problem. Sometimes find out some spare time. I know you're a busy lawyer. Some spare time, 5, 10, 15 minutes. So 2, 3 matters we can dispose of when Mr. Das is there. I also get some confidence then. Yes, Mr. NNB Chaudhary.
Yes, my lord.
Trustee service done.
Trustee service is done.
Everything done. Where is the affidavit?
Affidavit, my lord.
Some more time to file my affidavit.
Why? Who is appearing for the?
I am appearing for person of 5 and 6, man.
No. You were there earlier.
Yes.
The tourism, I suppose. No?
Tourism, yes.
Tourism.
2, 3, 4.
Okay. Oh, today everything is on behalf. This court is on behalf court for the respondents. Yes, madam, what do you want?
Should we can grant some more time?
Oh, I can grant time. There is no problem. But how do you face the onslaught of Mr. NNB Chaudhary? You will have to convince him first. But I'm going to take time. Otherwise, he will be going hammer and tongs.
Yes, no objection, madam.
No objection.
No objection.
You have a stay order.
Yes. They are just enough for me.
Okay. Mr. NNB Chaudhary, learned senior counsel, assisted by Mr. R.
H. Batra.
H. Batra.
And but and
Huh?
and but
And Batra, huh? Sorry, Mr. You forget something there. N. Batra, learned counsel for the petitioner. Also heard Miss L. Bakshi, learned counsel, appearing for the respondents number 1, 2, and 3. 2, 3, and 4. Also heard Mr. S. Bora, learned counsel, appearing for the respondents number 5 and 6. Both Miss Bakshi and Mr. Bora have prayed that they be granted further time till.
And even 10 days time, madam.
Madam? 1 week, 7 days, 10 days. Okay, time till 11/6/2026 to file their respective counter affidavits. Prayer accepted. The respondents are directed to file their to bring on record their stand by way of filing an affidavit on or before 11/6/2026. Registry on such filing of the affidavit by the respondents, petitioner is granted further.
And from 6 to 30, I am not available.
2 weeks time?
That's fine.
2 weeks will do or 1 week will do?
date will be fixed.
I'll keep fix everything. How long will you want to file a rejoinder? 11 they will file.
Yes, ma'am.
After that,
I will come 13, my lord.
you come whenever you want to come. You are senior, you will only come to court. You are not going to do these things. These things will be done by the. Yes, when?
Further 1 week.
1 week. The petitioner is at liberty to file a rejoinder thereto on or before 19/6/2026, if so advised. Registry to list this matter for admission hearing on 24/6/2026. Interim order passed earlier to
24.
24.
Can it be, my lord, 26, my lord?
25 is the last day.
26 is last day. Then we'll have it immediately after the vacations.
No, my lord, 25.
Let it be on
25 vacation, no.
Then bond hogi.
From 27 it is a holiday. Vacation will start.
27 and 29.
No. 27 onwards there is a vacation.
No, 26. 24 hote abore. 23rd, my lord.
23/6/2026.
24 my boy bina. My lord, interim order.
Interim order passed earlier to continue till the next two. In the Laujima Court's order dated 23/4/2026, which reveals that the service of notice upon the respond number 7 and 8 is complete. So accordingly, the registry to list this matter for admission hearing after 2 weeks. Only 7 and 8 was pending.
Yes, Lordship.
Yeah, please, your lordship. 2 weeks time may be allowed to file a IA for implement, lordship.
It's 2 months since we gave you time.
1 week, lordship.
On the prayer of the learned counsel for the petitioner, further 2 weeks' time is granted to file an interlocutory application for impleading the present incumbent in the post of District Commissioner Dhubri as a respondent in the present, as a respondent hearing.
Obliged.
And the amount sanction has been granted, my lord. The same has been communicated to Office of Accountant General.
Mr. I. Bhattakur, Learned Counsel, appearing for the respondents number 1, 2, 3, and 4. All
Yes, ma'am.
submits that the sanction for release of the contractual dues of the petitioner has already been communicated to the
Office of Accountant General, my lord.
why he disburses.
No, my lord, once communication is then made to the Treasury after that, man.
Okay. Is already made to the Office of the Accountant General, Assam,
Yes.
for doing the needful, and he submits that the amount involved would be released to the petitioner shortly. So, in view of the above developments taking place in the matter, this court directs the registry to raise this matter again on 19/6/2026, on which date Mr. Bhattakur shall apprise this court as to whether the amount has been credited to the account of the petitioner.
Obliged.
For none appears for.
41. Your lordship, today I have filed my affidavit, your lordship. I have filed today the affidavit, your lordship.
Okay, why this order is not complied with?
Lordship, actually, Lordship, FOC has been received on January itself, your lordship. May I place the copy? January itself, your lordship. There are 3 contempt filed regarding the same court order. And for the 3 petitioners, FOC was received. Lordship, 1 already disbursed. Other 2, Lordship, could not be disbursed because there is a change of IFSC code for transfer of their account from United Bank to Punjab National Bank, your lordship.
So what we are proposing?
Lordship, we have proposed for correction of the number, your lordship. That is approved also, your lordship. But lordship,
Miss Decca, RM Decca, Learned Counsel for the respondent submits that the processing for release of the admitted contractual dues of the petitioner is at an advanced stage, and the amount involved would be credited to the account of the petitioner within
lordship, within 4 months, your lordship.
4 months.
Because your lordship, because your lordship,
Within a period of 4 weeks from today.
no,
Get-
your
get
lordship. FOC was lapsed, your lordship. I have
2
filed
lakh
the
rupees.
affidavit, your
Okay,
lordship.
we will ask. 2,62,000. And this man is filed a writ petition, now a contempt petition, huh? And this order is of 27/11/24, 3
Lordship,
weeks.
Lordship,
In
kind.
the event, on the next date of listing, the respondent shall place before this court the compliance report envisaging the deposit of the amount involved in the account of the petitioner.
Lordship, FOC was lapsed, your lordship, because the
In the event the compliance report is not placed before this court on the next date of listing, the respondents, this court would consider passing orders, drawing up contempt proceedings against the respondents, and the personal appearance of the petitioners on the date to be so fixed. Registrate to list this matter against 4 weeks ko idiya. 13/7/2026.
Obliged, your lordship.
You are appearing so 13. Tell them.
Obligated.
Two lakh. It's sounds very. You are for which department? Water resources. 2 lakh. Sad. 2 lakh rupees water resources. Sure.
42 same, your lordship.
42 same water.
Obliged.
Complied.
No, Lordship, clarification have to come from the Deputy Commissioner's office, Lordship. Incidentally, they have not made Deputy Commissioner or the Finance Department parties, Lordship. Financial sanction has to be given by the Deputy Commissioner's office, Lordship.
You are appearing for?
For respond number 2, Lordship.
Who is that?
Lordship, Parthapati Mazumdar, Lordship, he is no longer holding
No,
that
no,
post,
whoever,
Lordship.
who was he?
He is no longer holding, he was the
Who?
Principal Secretary, Lordship.
Principal Secretary?
Home and Political, Lordship.
And who was the respondent number 3 in the original writ petition?
Lordship.
Deputy Commissioner.
Lordship.
Lordship, Deputy Commissioner Kufragar.
Yes, Mr. Bhagwati, why this amount was not sanctioned by you? You are to sanction it.
Lordship, I had filed an affidavit earlier, Lordship. The Deputy Commissioner's office was not providing us the required documents.
No, that is for you. Your headache
Lordship,
is
now I
of
have
yours.
given a letter, Lordship, my new letter, Lordship, that I have forwarded, Lordship.
This is contempt case number?
678, Lordship. We have written 4-5 letters to them, Lordship, Deputy Commissioner's office, Lordship.
Why a financial sanction is required from the Deputy Commissioner now?
Lordship, it has to go through them, Lordship, the total amount, what they claim, Lordship.
You have given the budget.
Lordship.
What more is required?
They have to provide it, Lordship. It will go to them, Lordship. They will disburse.
What is this happening? You have given the budget.
Lordship.
Sanction given.
Lordship.
Amount admitted. Sanction given.
Lordship, that amount.
Now what is to be done?
Lordship, my senior has stated that Deputy Commissioner's office needs to clarify the sanction amount, Lordship. They have
sanction amount is 25,53314, nothing more, nothing less.
Lordship, that the admissible amount is, Lordship, 21 lakhs, Lordship.
Amount claim, admissible, whatever it is. 20 lakhs pay him, don't pay him 25. Who asked you to pay him 25? 21, why is not paying? You give him budget, what happened?
Lordship, that is their letters is, Lordship. However, the financial sanction against
this was given on 13/5.
Lordship.
13/5, okay.
Upon receipt of the financial sanction proposals, Lordship, that has not yet been received. Necessary action will be initiated for issuance of and submission of FOC proposals, Lordship.
Oh, another 1 year.
No, Lordship, it won't take. Other cases are there. They will get it, Lordship.
The incumbent, who is the government advocate? You are no longer there.
No, Lordship. No, Lordship.
Any government advocate? Unnai. Mr. M. Bhagwati, Learned Counsel for the. Who is this Dilip Kumar Bhotra? He is the present person, no?
Lordship, no, Lordship. He is the additional secretary, Lordship.
Mr. M. Bhagwati, Learned Counsel, appearing for the respondent number 2, submits that the respondent number 2 is no longer holding the post of Secretary, Home Department, Government of Assam. However, he submits that the Home Department had already allocated budget for the release of the dues of the petitioner, admitted contractual dues of the petitioner. However, the follow-up steps is still pending. And after receipt of the necessary proposals from the finance, from the deputy district commissioner. District commissioner?
Also Kokrajhar.
Kokrajhar. The matter would be further processed for submission of FOC proposals to the finance department for release of the funds to the petitioner. The orders, the direction was passed by this court wide and order dated 8/8/2024. Nearly 2 years have lapsed since the directions have been so issued. However, the directions passed are yet to be complied with. In the affidavit filed in the connected writ petition, a stand was taken by the Deputy Commissioner, Kokrajhar, that the bills of the petitioner was forwarded to the government in the Home and Political Department way back on 26/7/2021. It is seen that the respondents are not eager for compliance with the directions passed by this court. So, however, considering the developments taking place, this court directs the present incumbent in the post of the secretary to the government of Assam Home Department to expeditiously process the matter to ensure that the dues receivable by the petitioner, admitted dues receivable by the petitioner, is credited to his account on or before 15/7/2026 or 17/7/2026. The compliance report in the matter be placed before this court. True. You can prove Mr. M. Bhagavati, learned counsel for the respondent number 2. Mr. Bhagavati is requested to forward a copy of the present order to the present incumbent in the post of secretary to the government of Assam Home and Political Department for compliance. A copy of the communication instructions furnished by Mr. Mr. M. Bhagavati, learned counsel for the respondent number 2, is kept on record and marked as X for the purpose of identification. That's it.
Here, my lord, the matter has been
Yes,
struck.
Mr. Infractors.
No, my lord.
Oh, then?
Not infractions, my lord. The struck at the, my lord, on the commission service on the respondent number 5, my lord. My lord, probably he had already attempted as per dates of this court, my lord.
Well, there is a problem, my lord. Lordship will see page number 5. The respondent has been named as Mrinal Jyoti Nath, who is the, according to the petitioner, has been allotted the work. His name is otherwise Mrinal Jyoti Das. My learned friend is appearing on his behalf, but Wakalanama, my lord, with that name is difficult, my lord.
Mr. S. Hope
You'll have to
submits
correct
that he would take appropriate steps for
it. It is for me.
correction of the name of the respondent number 5.
It is a Nath.
It is submitted that the it is submitted by the by Mr. B. Gogoi, learned additional advocate general,
Yeah, he
appearing
should do.
for the state respondent, that
The work has been allotted.
contract has been allotted to one Mrinal Jyoti Das,
Yes, ma'am.
apostrophe between, and not Mrinal Jyoti Nath. So, Mr. Hawk to file appropriate application for correction of the name of the respondent number 5. Such application be filed within a period of 1 week from today.
Right.
To make not Das, Das,
Yes.
it's all. Where is the order?
The order is at page 85, my lord, relevant page, your lordship will find. It starts from page 85.
Yes, Mr. Then what is the error? What
My
is the error?
My lord, at page your lordship will find we have taken the ground, my lord.
Oh, from the order you show me. What is the error?
My lord, paragraph number 12,
Huh.
15, my lord. Paragraph number 15 says, my lord, your lordship kindly see, be that as it may, as your lordship got it, my lord.
Okay, give me 2
Page-
minutes. Give me 2 minutes. Yes. You get 4,600, you got 4,600. What is the error?
My lord, our case was basically, my lord,
No, I want
Was-
error. Error in the judgment. Your case not considered appeal. What is the error in the judgment?
my lord, error is that this, with all respect, my lord, the order.
How can
is-
a review be filed by a separate set of counsels? Where are the first set of counsels gone? There is a decision. You can't file. Because what contention, now it's open to you. You can make any submission you want. But they may have made some submissions before this court. So how can a review be filed by a separate set of counsel? One.
For that,
Two,
my
what
lord,
is
I'll
the error?
satisfy.
What is
I'll
the error?
satisfy. My lord,
No time, no time, no
My
time.
lord, I'll
People are waiting.
satis-
What is the error?
error, my lord, there is conflicting order passed by this honorable court, my lord, by the coordinate bench of this honorable
Go
court.
up
my lord.
before, go up on appeal. That orders were not passed before me.
My lord,
Only on that.
my lord,
Only on that.
we prayed for, this is, my lord, beyond pleading. The order that has been passed, my lord, with all respect, my lord, it is passed beyond pleading. We did not claim for, my lord, file writ petition claiming, my lord, great pay. We filed the writ petition praying inter alia, my lord, prayer your lordship will find.
Yes. Show me the prayer.
Yes. Page 82, my lord. It starts from page 81. Relevant portion your lordship will find, my lord, page 82. Order or direction should not be passed by direct.
No. What is the SAP benefit you are claiming? What is that benefit you are claiming?
Through financial upgradation, my lord.
What is that financial upgradation you want?
My lord, that will be examined by them and they'll
What,
my lord,
Mr. Cost? How much?
my lord, your lordship.
How much?
That my lord, of
How
course,
much
I have,
cost?
my lord, that
Tell
of
me
course,
the cost. How much? That much only. It's because Mr. Sen is appearing. I'm giving the option to him.
My lord, your lordship kindly consider, my lord, we have
Mr.
prayed
Sen,
for,
this is too much.
my lord, we have prayed
This
for,
is too much. You are given one promotion, so you are only entitled to one ACP, 4,600, right?
no, my lord,
Given.
no, my lord. I have given after 24 years, my lord, there is, my lord, the ACPS is,
How
my
much?
lord, ACPS is,
How much?
my lord, your lordship kindly say, ACPS is one after 10 years of regular service, another after
That is
14 years.
MSCPS.
Yes.
That is MSCPS. ACPS is 12 and 24.
10 and 12 and 24, my lord. Yes. But during 24, I did not get any promotion, my lord.
You
That
go
is
upon
my
a
case. That is my case, my lord.
Yes,
And
Mr. Sharma.
we did not pray for, my lord, great pay, my lord. We
Grounds
prayed that
available
the
for review,
my lord,
Mr. Sen,
my lord,
please don't make such submissions.
your lordship,
You don't get anything more than a great pay in a.
prayed, my lord. Your lordship kindly see, we
Okay.
prayed, my lord, order dated
Until on a counsel for the parties, however, the petitioner has not been able to
my lord,
satisfy this court about any error existing in the order review of which is sought for. Mr. Sen prays that he be granted further 1 week time to make his grant him 1 week time to make further submissions in the matter. Mr. B. Sharma, learned counsel for the petitioner, does not object to the said. Learned counsel for the AG, Assam, does not object to the said prayer. Registry to list this matter again on 11/6. 11/6. You satisfy me, otherwise withdraw, otherwise cost. Or full order, whatever you want. First time. Yes. Mr. Sen, read the SCPS, MSCPS scheme properly. Then
that scheme I have gone through, my lord.
Mr. Sharma, you also examine if there is any error. Yes.
All right.
Please it your lordship. Lordship, in this matter, service upon all the respondents is awaited.
Registry to await completion of service upon respond number 1 to 4 for further 2 more weeks.
Bless.
May I please, lordship? Lordship, this IA is filed for extension of time to comply the order, lordship. Initially, the lordship, the central PWD executed the contract work on behalf of lordship Central Silk Board, and Central Silk Board is not releasing the fund, lordship. Therefore, it could not
May I
be.
please, lordship. Lordship, this is not a new ground, lordship. This ground was already there while
Yes,
disposing of the
sir.
writ petition also, lordship.
Okay, we'll have to consider this. There is no time. On the prayer of the learned counsel for the registry, for the parties, registry to list this matter again on 8/6/2026. We'll see on 8/6.
Thank you.
I filed and passed an order, but Mr. Sheikh did not, I did not see the file also. That the writ petition was disposed of. How can I pass this order? Once in a petition is disposed of, how can I pass an order for correction?
I was disposed of, my lord.
The writ petition was disposed of prior to that. This was not told to me. And my mistake, I did not go in. When it came from the registry only, I came to know. So, heard the learned counsel for the parties. The present interlocutory application was disposed of while order dated 27/5/2026, permitting the petitioner to carry out the correction in the address, in her address as set out in the writ petition. While passing the said order, this court had overlooked the fact that the connected writ petition being WPC number
1172 of 26.
1172 was already disposed of by this court on 2/3/2026. So, the said aspect of the matter having come to the notice of this court, this court had directed for listing of the matter, list present writ petition today. Accordingly, the order dated 27/5/2026 stands recalled. The registry is directed to list the interlocutory application again after a week on a date to be fixed by it.
My lord, we have already filed the amended cost title today. Based
The
on that,
registry is
27
directed not to carry out any correction in the cost title of the connected writ petition that is so and so till final consideration is made in the interlocutory application which has now been directed to be the present interlocutory application which has now been directed to be restored to its file.
Much obliged.
So Pang, it's overtime today. You are staying back.
Your lordship is sitting down, that we have to stay.
None appears for the petition on call. Registry to discuss matter again on 10/6/2026. Dia tanya. Ini mukti di bawah betul. Iya sekali itu siapa saja. Yes, Mr. Goswami, anything?
My lord, I am waiting for item number 18, my lord.
Oh, 18, the morning mention was made. I did not give. Thereafter, nobody appeared. So I
Well,
have checked it on 10.
My lord, actually, I was on online, my lord. My petitioner is also online. Somehow we have, my lord, missed, my
You are
lord.
petitioner. Mr. Hassan.
Yes, yes, my lord.
Mr. Hassan, you are for 18. Item number 18.
Yes, yes, your
All
lordship.
right. Okay. What is your case?
Lordship has fixed it on 8th, I think.
Oh, today itself. I did not know you were appearing. Your junior did not turn up thereafter. Now tell
Lordship,
me,
lordship.
Mr. You bid by left hand. Then you say, "Ore, it's very hot, I will not touch it." Then you come with right hand and you collect it and go. And now you want everything to be done in terms of the left hand tender. This is not permissible.
I have not collected anything, your lordship.
Okay, we'll have it here.
I have not.
Kiman tarik disu? 10th, na? 10. We'll have it here.
8. Lordship.
10/6.
Oblige, lordship.
Because I find this bona fide to be not correct.
Well,
bona fides are doubtful.
Lordship.
এইটো লিখি দিবা গোস্বামী আৰু নাম লিখি
For the